Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-3035, United States of America appellant versus David Jeremy Zobel. Mr. Coleman for the appellant, Mr. Kramer for the appellee.
Good morning, Mr. Coleman. You may proceed whenever you're ready.
Good morning. Thank you, Your Honor. May it please the court, Nick Coleman for the United States. Before I forget, I'd like to reserve 2 minutes for rebuttal, please. Before addressing the merits in this case, I think it's important to address the timeliness issue. Obviously, that's a threshold issue. This appeal is timely as to all categories of evidence which the district court excluded in this case. But I think it's helpful, as we explained in our brief, to sort of look at each category separately, because I think that helps make this issue easier. We call them buckets. There's any other way that you can refer to them. The first such bucket, I think, actually, as to the first 2 buckets, I think the timeliness issue is pretty easy. The statements that Mr. Zobel made during the chats here and the photographs that he sent, in which he referred to his prior offense, the district court did not even hint that it was going to exclude those until February 25th of 2025. The government filed its notice of appeal on March 18th of 2025, so that was well within the 30 days. That is also true as to the second bucket of evidence, that was testimony by an FBI case agent and by Mr. Zobel's probation officer, in which the district court indicated, again, beginning in February 25th and at the next 2 hearings, that the evidence would have to be heavily sanitized, so that essentially no reference at all to Mr. Zobel's prior conviction or the fact that he was on probation could be stated. Again, those rulings did not come until well within the 30 days of the government's notice of appeal. So that brings us, I think, to the final bucket here, which is the plea proffer details, or the summary of them, which the government sought to introduce. Now, the defense is certainly correct that the government initially moved to introduce those back in 2023. And the district court excluded them in its initial ruling in September of 2023. However, at that time, the district court indicated that it would revisit that issue if identity came to be challenged by the defense. When that, yes,
Coleman, if the chats and Mr. is it Zobel or Zobel?
I think it's Zobel is my understanding.
Mr. Zobel's own description of his prior criminal conduct and assertion that he had been convicted, and why, if all that comes in, why is the plea proffer summary even needed?
Well, I guess I'd step back and say this. If all you have are the chats in which a person is saying to the undercover officer, from page 1, I'm a middle-aged sex offender, and then he describes that he had been convicted, he'd done 10 years. Here are the things that I did to my, to these girls before, one girl and then her friend. If all you had was that, and then you have a photograph which he sends, but he covers up his name and part of the case number to the undercover officer. If you just had that, you wouldn't know that that is Mr. Zobel. You'd need to know, if you wanted to show that in fact was Mr. Zobel, you'd have to establish, how did the FBI get to him? And in fact, the way that they did get to him was pulling up, because they could see the ECF number, they could see the partial case number, the court it was entered into. They were eventually able to figure out what the judgment was that Mr. Zobel had sent, and there's his name. So that's why.
That seems to support the premise of my question, which is, if you had the chats and you had testimony by the FBI officer, the name was covered, but we were able to use the court, the date, the case number, and find this individual, find the defendant. Then, again, I'm trying to understand what more in that summary is probative, in part because Judge Leon was, that was the first thing that he saw and that he reacted to as unduly prejudicial.
So I think the problem is, again, that even if you get in, say, that law enforcement testimony, like, yes, he was convicted of this offense, which I think was enticement of a minor, that still wouldn't put in other words, that how closely his conduct in that case, the 2011 case, matched what he told the undercover officer about what he'd done. So again, that shows, Mr. Zobel is sharing with the undercover officer, not just the fact that he's been convicted, but also what he did. And it matches up very closely to what he told the undercover officer. So again, it is evidence of really three things. It is evidence of his identity, because it shows that, it's not just that, this is a person who's pulled up Mr. Zobel's conviction and is sending a copy of that judgment to the undercover officer. This is somebody who knows what he did in the case. First, as to that. Second, it shows his intent to commit this offense, which is the attempted sexual exploitation of a minor, because he's taking this incredible risk and sharing his status as a sex offender with the undercover officer to gain his trust.
That I follow. That's part of the offense conduct. I guess so the premise of your answer just now was that Zobel himself might have been puffing. He might have been convicted of some other kind of less lurid and, prejudicial, whether appropriately or not, conduct. And so it needs to be verified by the summary of the plea. I mean, he's saying what he did. To the undercover. So the person on the chat is saying.
Right. I mean, it is possible that a jury could think, was he puffing? Okay. In other words, did he actually?
Is that your point? No.
So again, that's part of it. But I think it's also, in addition, if he's going to challenge identity, if he's going to say somebody else was essentially impersonating me, the more details that the person who is engaging in the chats is sharing about what the real Mr. Zobel actually did, the less likely it is that this is somebody who is impersonating Mr. Zobel.
And the more those details match the actual facts of the offense, the more compelling that inference.
Yes, that is absolutely correct, Your Honor. I think it also goes, again, under Rule 414, it also, goes to show his sexual interest in young children. Remember that particular offense, just the actual, page that shows the thing that he was convicted of. It does show that, it shows that he engaged in enticement of a minor, but it doesn't establish his sexual interest in young girls, which, yes, he expresses all of that during the chats. But this is what shows that it's not just a fantasy. I mean, that is one of the primary defenses. It was the defense in lieu. It has been the defense in many cases in which a defendant who is engaging in these chats online or communications with an undercover officer.
So this evidence, he's indicted on 3 counts, right? 2 distribution of child pornography counts as well.
Yes.
Are you contending that any of this evidence is admissible for those counts?
Yes, it would be under Rule 414. Now, again, it would show his sexual interest in young girls. The fact is that among the details that, the particular details which the government did seek to introduce from the prior offense was the fact that he'd uploaded, I think it was 61 sexually explicit, images of child pornography. So yes, it does show what Rule 414 permits. It does also show that, that his distribution, he intended to distribute child pornography. He was aware of the images that he was sharing with the undercover officer. So yes, we do think it is relevant to those 2 counts as well, but it is especially relevant, yes, to the ASEM count, in which there has to be, it does have to be shown that he intended to get the undercover officer to create these new, or basically to perform child abuse where Mr. Zobel could actually watch it.
The intent points seem to me particularly important on count 3.
Yes, you're right.
But the identity question went to all 3 counts.
Oh, absolutely. Right. I mean,
If he were going to say, sure, someone did sent all these criminal messages to the undercover. It just wasn't me.
Yeah. And I think, again, I think as to all of this evidence, if we're now addressing the merits question, I think, again, one of the problems I think with the district court's ruling is that you can almost see in the final rulings from the district court beginning in February, the court, I think, sort of sensed that it didn't really make much sense to exclude the plea proffer details once all of this chat evidence is coming in. And that's why the district court turns around and says, well, actually, you can't even admit those chat statements either, government, because that will interfere with my Rule 404B ruling. So I think the court itself sort of sensed that once those chats are admitted and once it's understood that they're properly admissible, the cat's out of the bag at that point, and particularly given that Mr. Zobel, although he has been very cagey, I think, in all of those hearings starting in February about exactly how he was going to be challenging identity, it's clear he's going to be. He is not going to stipulate to anything. He's not going to stipulate that it was him at all engaging in those chats. And because of that, yes, Your Honor.
You said that it doesn't make much sense, that you suspect that the district court kind of realized it didn't make much sense to preclude the summary if the chats were included. But another way of looking at that is that he intended from the beginning to preclude the references in the chats. And I know the government seemed surprised by early 2025 that that's how he was reading it. But it's possible that he's saying, I'm precluding as unduly prejudicial any reference to the prior offense. And if that's right, then you may have a timeliness.
So all I can say is this: there is no hint in May of 2023 of the hearing on that motion, or in September 2023. There is no hint there that the district court is saying that those chat statements are not going to come in. The government didn't hide them at all. If you look at its motion in limine, it said, here's all these chats, and we are seeking to introduce these plea proffer details because they corroborate them. We think it goes to both his identity and his intent. The trial, the district court here said, I'm denying that motion. He said that he would reconsider if identity became an issue, but at no point, and I have looked and looked and looked, but he had never said that he was going to exclude those chat statements.
Let me just to focus in on the claimed legal error. So your claim is that the district court legally erred by treating a propensity inference as unfair, given 414, for the purposes of the Rule 403 balancing.
So
that's sort of the core error. I mean, propensity 414 says propensity is okay.
Yes.
In this type of crime. And yes, there's a balancing, but what the district court said was, it sounded sort of like non-414 balancing under 403.
I think that's right. I mean, I do have to say that in all fairness to the district court, if you look at how the district court approached this back in September of 2023, there is some language there, I think, from the district court that doesn't quite take into account the purposes of 414, which is the fact that this kind of propensity evidence is now admissible. But the district court is also, I think, expressing a concern that perhaps can come into play, which is that at time it could be that the details of a prior offense are so intense that a jury could feel that, would want to punish the defendant for that prior offense, would just be so offended by that.
That's exactly what the district court said.
Right,
So
and that's why I think it's there.
The district court never said that I see. I mean, tell me where in the transcript the district court says that this is improper propensity evidence. Where does the district court say it?
So I do think that the court does refer to that, but I 100% agree with you, Your Honor, that the other concern is something that the district court stated.
The district court says that this creates a great risk that the defendant will be judged based on his prior acts rather than the facts of the present case, JA 269.
Yes, and
Bottom line, right?
I think
And that's a
that,
proper statement of
Right.
how one is supposed to do the Rule 403 balancing, isn't it?
and I think I would agree with you, Your Honor, that under Rule 414, that is still a permissible consideration for a district court. I think the problem becomes that once, at that time, and again, we are not here today. There would be a timeliness issue if we were appealing directly that ruling, okay? We didn't appeal that ruling at the time. The problem, I think, now is that at that time as well, though, the district court indicated that part of why it was ruling that way was because that in that very same transcript, the court says, I have no reason to believe that Mr. Zobel will be contesting his identity. That changes, and it changes the calculus, and yet the district court does not engage in a new balancing.
So
Instead,
that is the error that you tell me the legal error that you
Right.
believe the district court committed.
So
It's that the district court, once the new facts emerged, that identity would be an issue, that the district court didn't conduct a new balancing.
Or rather that I think that once it did, the court essentially said, I'm just going to exclude this, all of it, no matter what. And, whether that's, again, I don't think it actually engages in any sort of new balancing test. As to the plea proffer details, okay, again, this is only about this particular bucket because that's the only thing that the district court ever really engaged in the Rule 403 balancing that back in September 2023. By the time we get to February and March of 2025, things have definitely changed. And the fact that Mr. Zobel is going to be so, essentially will not concede anything and is going to say that, essentially tell the jury, they can't prove it was me. That's going to be the central defense. Then yes, I think as the district court had promised back in 2023, it was incumbent on the court to reevaluate that. And in fact,
Where does the district court, is there a point in the transcript that you can point me to where the district court says that he's not going to allow any of the chats to be introduced, or where is the best articulation of the district court's ruling with respect to the chats?
Yes. So I think if you look at on the March 17th transcript, okay, first of all, at the very beginning, this is on A403 through 404. Judge Leon informs the government that he's got additional redactions now that he's going to insist on with the chat transcripts. And Judge Leon then on A414 says, I have been crystal clear that no reference to his prior conviction, no reference to his being on probation is to be made. And that was right after the government had asked Judge Leon to clarify if his ruling was that all references in the chats to Mr. Zobel's being a sex offender, having a prior conviction, or being on probation must be redacted. So I think it was pretty clear what Judge Leon was saying there, which was that he did not think that any reference in the chats. I mean, that was why I think it was so difficult for Judge Leon to agree to even introduce the chat transcript to the jury as an exhibit, because it was going to have these big redactions on 15 pages of the 55.
So I'm old enough to remember when people used to talk about race gesti as a part of the rules of evidence. And isn't the chats, I mean, intrinsic evidence as opposed to other crimes evidence? I mean, if I walk into a bank and hand the teller a note that says, give me all the money or I'll kill you, and then the teller refuses, and then I say, I've killed 10 people in the course of my life, and, I'll make you number 11 if you don't give me the money. Is that other crimes evidence, or is that just intrinsic evidence that's part of the crime?
Oh, it's certainly intrinsic evidence. I think I absolutely agree with you that the chat transcripts here are the offense conduct. I mean, all of this conduct occurred online. It's like if you watched a video of the crime, and yes, I absolutely agree with you that when
that's why I'm like wondering why you're not arguing that like analyzing the chats as other crimes evidence at all, it was error.
So again, I'm not sure that the district court really, I think the district court basically said he thought that he could remove all of those references and say, well, those are just extraneous to the crime. I think that was how the district court approached it. I mean, again, it's not very clear because he doesn't issue sort of a written or, pre-written ruling. He just seems to say it and just seems to think that it was somehow a part or essentially required by his earlier ruling from a year and a half before. I can say this, that yes, there is a way to look at this as sort of, it is absolutely intrinsic to the crime. It was in fact part of the commission of the crime. And just like the bank robber wants to say, I've killed 10 people so that the person he's talking to will believe that he will do it. Here, Mr. Zobel wanted the undercover officer to really be sure that he was a safe person to do all this conduct with. So yes, I think Rule 414 sort of makes that intrinsic, extrinsic, distinction not quite as significant now in the case of sex offenses.
Right, but I guess, I agree with Judge Wilkins' question in the sense that, partly it's because the district court was looking at it all as extrinsic evidence of prior crimes. But it just seems to me that for you, especially given the ambiguity that your prior colloquy with Judge Wilkins covered, where on the one hand, it seems to me the district court, sounds like he's putting aside the potential propriety of propensity evidence under 414, and then but then also talks about, this is more vivid and potentially more troublingly and gratuitously prejudicial. Like given the problems with the prior crime ruling, that maybe it's error, maybe it's not, that it's so important to your case, and you do brief this, but it feels like it's being downplayed. And I guess all I'm trying to understand is it and why? What is the vulnerability for you? Because both for identification, but also for motive and intent to actually go through with it. As these cases, one of the defenses it was really fantasy. We were talking as if we were going to meet, but that's part of the heightened fantasy. Really, that's not what this was about. And that the prior crimes is, as he says, is relevant to my bona fides.
Oh, no, so look, we think the chats come in, okay, all of them. They come in fully. There's no question whether one wants to think of this. And I think it absolutely the most direct way home. I would 100% agree is that they are just part of how he committed the crime. In fact, they're a vital part of how he committed the crime, because this, he was he was deploying his status to gain the undercover's trust. So I don't, regardless of what way you want to think about this, is it really intrinsic to the offense and therefore we don't even need to think about 403. But again, 403 sort of says that you have to look at every bit of evidence. It's just that here, I think it's somewhat silly to say, is its probative value outweighed by its danger of unfair prejudice? The answer has to be absolutely no, because it is the crime. Now, once you take that as a given, once those chats are coming in and he's bragging to the undercover officer about his bona fides as a sex offender and what he's done in the past to gain his trust, and he's now at trial going to challenge identity, there are a lot of different now reasons why it is important to prove that what he was talking about was real. First of all, because it does show his identity. Second, because, again, he's exposing himself. He is really exposing himself to some problems. He's on probation, as he tells this undercover officer. This is how he pinky swears during the chats that he is not a cop. And this is how he's showing that. And the way that he's showing that is to say, I am a sex offender. I'm safe. I'm on probation. That kind of exposure shows how serious he was about committing this offense. He wanted these new images.
So let's suppose we agree with all of that. Usually you're on the other side of the table. And it's the defense who's saying, there was an error in an evidentiary ruling, and the government is relying on the deference and all of that to say that, we don't armchair quarterback, second guess district courts on these things. So let's suppose I agree with everything he said. Given the standard of review, why should we reverse? It says grave. We have cases that say grave abuse of discretion, not just regular abuse of discretion, grave abuse of discretion.
So I guess what I would say is obviously there has to be a fair amount of discretion given to district courts. Nevertheless, I think it's also important to remember that Rule 403 is weighted towards the admission of evidence. So it should, in fact, be significantly harder to justify the exclusion of evidence, of relevant probative evidence under Rule 403 than it is to admit it. I think, this court said that in lieu, Rule 403 establishes a high barrier to justify the exclusion of relevant evidence. And that's why the probative value has to be substantially outweighed by unfair prejudice. I think, again, the 10th Circuit has said that, exclusion should be an extraordinary remedy, which is used sparingly. And I think one of the best ways to put it is one of the cases we've cited in our brief, Rodriguez from the 11th Circuit says, in looking at 403 cases, you should look at the evidence in the light most favorable to its admission. I think that is why here, again, this is not something that normally, yes, we're on the other side, and that's because we have the burden of proof, and so we're trying to admit evidence, and the district court will usually, under Rule 403, because it's weighted heavily in favor of admission, it will admit the evidence. There will be a challenge to that, and normally the trial court is not going to have abused its discretion. I think, again, it's also going to be true for the defense. If they're trying to admit evidence, say in this case, Mr. Zobel wants to introduce evidence about other people in his residence, he's going to have a fair amount of leeway to put that evidence in. He just is. And, because again, he's got to try to make whatever defense out he wants to make. But I think it's important to remember that although a district court has discretion, that discretion isn't a license to be arbitrary. It's not a license to sort of say, well, in this case, I'm going to keep it out, but I'm not going to necessarily clearly articulate the reasons for it, and I'm not even going to reconsider when one of the bases for my ruling, namely that I did not have any reason to believe that Mr. Zobel would contest his identity.
The district court did reconsider and said that I still think that like even with a limiting instruction that the prejudice is going to far outweigh the probative value, right?
I'm not sure that he said that after he was asked to reconsider. Maybe I may be missing something right now, but I don't recall him sort of engaging in a lengthy discussion about the limiting instruction. He did talk about the limiting instruction in September 2023. I may be wrong about that. I don't remember any extensive discussion about a limiting instruction after February. I could be wrong about that right at this moment. I don't remember him going, however, into a sort of lengthy reconsideration. He did, talk about all the other ways that he thought that the government could show identity. We've described in our brief why we don't think that those are nearly as strong as the plea proffer details in showing that this was Mr. Zobel. They are all important, and we intend to introduce them. But I think, again, it's also, as the Supreme Court said in Old Chief, and I think as this case, as this court said in cases like Gartman and Liu, the government shouldn't have to so sanitize its evidence that it doesn't show what really happened and, sort of what was really going on in this case.
Do you think the district court committed discrete legal errors embedded in its analysis, or do you think mainly that the court just abused its discretion in conducting the balance?
I do think that, I do think that even in September 2023, that the district court may have been overly focused on the propensity evidence without
Impermissibility
Right.
of a
I mean,
propensity inference.
If you look at the district court's, hearing that it held in May of 2023, the district judge referred to his time, I think, in the Southern District of, he said that his approach to other crimes evidence comes from his experience as an AUSA.
So if we agree with that and conclude that there's a legal error embedded in the analysis, why would we reverse outright and order admission of the evidence rather than just laying bare the legal error and remanding for the district court to redo the balance under correct legal standards?
We think this court, obviously this court could do that. We do think, as we've explained in our brief, why we think the evidence is just flat out admissible, and that we don't think that in this case, particularly given the defense that Mr. Zobel is proposing to put on, however he's going to do it, but given that he's going to contest his identity, it's hard to see how a proper Rule 403 balancing, particularly since it's weighted in favor of admission, could come out the other
And
way.
I agree with you writ large, but there still could be a fair amount of discretion to just sanitize one or two ticks more. You look at the summary of the past offense, and you all took out some of the salacious details the first time. You took out a few more details the second time. Maybe he can take out one or two more without excluding it. And same questions of degree for the chats.
So I think as to the chats, I don't think that would be permissible. I'm not aware
None
of
it. Not even some.
I don't think so, Your Honor. I have not found a case in which, again, I haven't been able to do an exhaustive summary of every federal case out there, but I have not found a case where a court excluded the boasts made by a defendant during the commission of the charged offense, where the person is boasting about prior offenses in furtherance of the new offense. I don't see why that, I just don't see why that is something where, and again, I think this goes back to the fact, this is part of the commission of the new offense.
But to answer Judge Katsas's question, can you give me any case from our circuit where we have compelled the introduction of evidence that was excluded before rather than remanding for the district court to correct whatever legal error which was the basis of the abuse of discretion?
I don't think I found one from this circuit. We have found a number from other circuits, which we've cited in our brief, where the circuits did conclude that the district court's exclusion of evidence was a abuse of discretion, and that the evidence should have been admitted. Miller is one that we've cited. Rodriguez is one that we've cited. There are a number of circuits who have said that actually, look, this evidence comes in under Rule 403, and it was an abuse of discretion to exclude it.
But I don't think that's really responsive to the point that, or the premise of Judge Katsas's question, which is there's a lot of evidence here. There's potential overlaps. It seems like it's hard to imagine that we would micromanage exactly what goes in and what stays out. At most, we might say there's a legal error with respect to the interplay of 414 and 403, and that he didn't, it strikes me that the district judge didn't really take on the government's argument about this being actually part of the criminal conduct. And one would want to have the district judge really confront and address that. But in the first instance, it's really for the district judge, no?
So I'm not sure that in this case that it is necessary to go back for that particular discussion. I think there is a stronger argument that could be made that a remand might be appropriate for consideration of the plea proffer details. I don't think that there is really much argument to be made at all that the chats, in other words, what Mr. Zobel said in order to gain the undercover officer's trust can be excluded. Again, I have not found a case that has said that that is properly excluded, so I'm not really sure why one would go back for that. I think...
Did the government ever propose text of a limiting instruction in this case?
I don't know that we got to that point, Your Honor. I'd have to go back and check because I don't have in the record right now, at least not that I've seen, sort of the proposed jury instructions, and I don't have it right in front of me. I don't know, but I think, again, I don't think it would be hard to come up with a limiting instruction. I mean, and again, there have been numerous trials in other federal jurisdictions.
I understand that, but I mean, the government bears some responsibility when it is seeking to introduce evidence, especially evidence under 404 or 414 for that matter, of not just saying, okay, here's why we think that it's relevant, but to the extent that there is an argument that it could be unduly prejudicial, here's how we can mitigate that, and here's a proposed instruction. I mean, I see that happen all the time.
Yes.
And once the court said back in 2023 or that it didn't see how any limiting instruction could cure the unfair prejudice, I mean, why wouldn't the government, when it comes back to this, in 2025 say, okay, well, here's how we think a limiting instruction could deal with the prejudice, and here's some language.
So I know that there are standard jury instructions that deal with this. I don't have them at my fingertips, but I don't think it's a secret in the district court that these are out there and that they've been used in numerous trials. I mean, obviously there was one used in lieu there, so I don't think.
But
Go ahead.
Limiting instructions by their nature are very case and fact specific. And whether they're going to work or not depends on what the other counts are, how the evidence is going to be used, what other evidence there is. And so you can't just cookie cutter, cut and paste limiting instructions. At least I didn't as a district judge. And I don't think that that's the way you do things. You can't really assess it until you see it. And so all I'm saying is that part of your criticism of the district court was, its ruling that that the 403 balancing ruling was improper, but baked into that is a consideration of whether a limiting instruction could mitigate any unfair prejudice. And all I'm saying is that it's a little unfair to the district court to say that the district court got that balancing wrong when you never proposed a specific limiting instruction.
So I don't think we ever got to that point, Your Honor. And again, if the district
My point
court
is that you get to that point when you filed a motion in limine.
we always
You propose it when you say we're proposing that you introduce this evidence, and here's how we propose to instruct the jury about how to use it.
All right. So I guess what I would say is certainly we could do that sort of as a matter of course in all of these cases. I think part of it is that the introduction of prior sexual offenses, particularly under Rule 414, has, become something that's not at all uncommon and for which there are standard jury instructions is my understanding. So, but again, if the district court had thought that, look, we really need to think about how we're going to do a limiting instruction, the district court could have said, propose something, or let's see, or I think we would have to modify, but there is no indication ever even in September 2023, that the district court thought that its ruling was dependent on how strong the limiting instruction would be. But we don't even have that discussion at all, and it's starting in February of 2025. I mean, the district court doesn't seem to have thought.
You have it from the perspective of the defense is the problem.
Right. Well, the defense
The defense says in February at I'm looking at A317 and A319, and I believe that's in February of 2025, that, if this is going to come in, a limiting instruction at a minimum would be appropriate. And then the defense makes the argument that I think that the probative value is outweighed by the prejudicial effect, even with the limiting instruction.
So we've never, we've never argued at all below that limiting instructions would be inappropriate, even as to the chat statements. But nevertheless, again, I'm not sure what those look like in connection with the chat statements, because again, I haven't seen any court that has thought that under the Rule 403 permitted it to exclude, brags and boasts by a defendant during which he, deployed in furtherance of the crime. But we could do that. We could do that.
Here's one reason why I'm beating you about the head and shoulders about this. The advisory committee notes say in two separate places that the trial courts should weigh the effect of limiting instructions as they are doing the 403 balancing. And so, it's not in the rule, it's in advisory committee notes, which obviously don't bind us or district courts. But one could say then that, in exercising their discretion, trial court should explicitly consider what a limiting instruction would say and then analyze why that would or wouldn't cure or sufficiently mitigate any unfair prejudice. And one could say, well, the district court didn't do that here, and so that's problematic. But it's a lot less problematic if the government never really asked the district court to do that by proposing a limiting instruction or explaining why a limiting instruction would cure any unfair prejudice. You see what I'm getting at?
So as I recall, Your Honor, I believe that our motions in limine to admit the plea proffer details indicated that we thought a limiting instruction would be sufficient to cure the prejudice. So
in fairness to the government, yes, you did say that in your motion, but you didn't say what it would say or how it would do it or anything.
And we could start, including, we could start including the standard instruction. And then if we thought it needed to be adjusted, we could propose adjustments. I don't think, again, when that motion was filed, we were far in advance of trial. Normally the instructions, the instructions come much closer to the trial date when proposed instructions are starting to be discussed. That just is my understanding of sort of how the trial practice normally works. It could be done, I suppose, earlier. And, we could certainly start doing that in the future when we file these motions in limine. I do think that at most this particular discussion, goes only to the plea proffer details. I'm not sure that any limiting instruction is needed at all when we're talking about the chat transcripts, because again, those are the evidence of the crime and how it was committed. And I don't think that the jury has to do anything other than look at this is what was going on. Now, again, when you start bringing in the corroborating information about what Mr. Zobel did and why it corroborates, in other words, this shows that it's him and it shows his intent, then you do have to give some instruction, which I think will be very similar to the standard instruction that which was given in lieu and given in other similar cases, would be sufficient to make sure that the jury doesn't judge him based on the prior conduct, as opposed to, only relying on the permissible propensity inferences that are allowable under Rule 414. And, beyond, and as it shows identity, as it shows intent. But, I think, in all of this evidence, I think all of this evidence is admissible in this case, particularly when you look at the kind of defense that Mr. Zobel is proposing to put on, which is that he's going to contest everything. He's not going to stipulate to anything. He is not going to admit that he was the one engaging in these chats. He's going to try to, as best he can, say it could have been someone else. You, government, haven't proven that it was me. In light of that, I don't think that, Rule 403 permits of a different result, given that it is weighted so heavily towards admission. If there are no further questions, we reserve whatever time. Oh, I'm sorry.
We've talked a lot about the chats and the description of the past offense. Can you just refresh my recollection for 30 seconds about your third bucket?
Yes.
Do you reverse outright or vacate or?
So we think again, like if this court rules as we think, Rule 403 and 414 point, then I think the particular evidence that's the issue there is, first, there's the probation officer who's going to describe Mr. Zobel's living arrangements. That's important because Mr. Zobel is going to try to say that other people could have had access to this phone. That other people could have gained.
It goes to identity.
Right, it goes to identity. Then there is the evidence from the FBI case agent who used the photographs that came from that Mr. Zobel sent during the chats to identify Mr. Zobel. There's that evidence. In other words, and they're the. Go ahead.
Sorry. So just on the probation officer, again, one can imagine gradations. Maybe the probation officer can describe the communal or private aspects of the living arrangement, but that wouldn't necessarily require using a term like halfway house or saying the guy was on probation.
Right. So that was discussed at length. And I think part of the problem is that the district court seemed to have this idea that the probation officer was not going to say that he was a probation officer, which I think does sort of raise the question as to why is he going back every month and inspecting Mr. Zobel's residence? Who is he and why?
I'm just a little bit sort of with you at some general level, but struggling with this point that it's not really a unitary choice, an on-off switch. Either everything comes in or everything stays out. And working out the details of that, it's a little bit hard and awkward and maybe inappropriate for us to do right now.
Understood. I do think, though, that given that Mr. Zobel actually sort of announced to the undercover officer, I am on probation, and then he sends this judgment that shows who he is, and then the FBI agent is going to say, in fact, we think properly should be able to say, we pulled up his judgment and look, it matches. This is him, even though he covered up his name with his hand. Once that comes in, it's hard to see what the point is of making the probation officer sort of dance around why he's there, what he's doing there. I think at that point, then the jury is going to. This I think brings up the point that the Supreme Court made in Old Chief, which is that at some point you're abstracting things or sort of keeping things from the jury. The jury's going to wonder, like, what am I not being told here? Why is this person going to that residence on a monthly basis? Why is he looking at Mr. Zobel's residence and like checking where the locks are? Who is this person? Why is he there? I think
I take
as the facts are, that's how I think it falls. So,
all right.
Thank you very much.
All right. Thank you. We'll hear now from Mr. Kramer.
Thank you, Your Honors. Good morning, and may it please the court. The government talked a lot about abuse of discretion and grave abuse. The only grave abuse that's happened here is the government's violation of 3731. This court has no jurisdiction to hear this appeal under 3731. In fact, the government essentially admitted it to you in their argument here when they said, they were asked, what is the legal error that Judge Leon made? And they said, possibly the only legal error, not factual, but the only legal error was in the September 2023 ruling when he was talking about propensity. But no appeal was ever filed from that order. That should end the case right there, because they're saying the only legal error that was ever committed, they say possibly by the district judge was in the September 2023 ruling.
Isn't their position that they could have lived with that if it turned out that Mr. Zobel was not going to contest identity, and if they could use the chat transcripts, and all of that changes by the time they decide they need to appeal?
Well, there's no indication that that was necessary, that they had to live with the chat transcripts, because they said at the very beginning, at the original hearing, in this case, at the appendix 238, the government flatly stated that it was not contending that it couldn't prove its case without this evidence, that it had sufficient evidence to prove the case without this. They conceded that.
Meaning the summary of the plea. Isn't that this evidence
that was
discussed then?
Well, that was the evidence, yes, being discussed then. But then they filed the fourth motion they filed was identical to that motion and said the same thing. The only motion they filed two motions that were a little different. One in January 2024 that was never responded to, never ruled upon, they never brought it to the attention of the district court that it was outstanding. Then they filed a motion on February 21st of 2025, just before the trial, with these, what they are now calling buckets that they did not make any reference to in the district court. The cases are, you can't just keep filing motions and adding, embellishing them and adding things. But most of all, it ignores what the government told the district court. I didn't hear one word about that when they said the successive motions on February 21st and March 14th were essentially just renewing the arguments that we made in the original 2023 motion. Asked again, they had another chance to talk about it. And they said the March 14th as well as the February 21st motions were both renewing arguments related to 404B and 414. That was what the people who wrote the motions argued them in the district court said, these are the same motions. Why the district court would think that these motions were different is beyond me when they've just told them that they weren't.
Well, but they argued, I mean, I'm repeating myself. They argued that the new defense counsel for Mr. Zobel chose to say we are going to contest identity in one way or another. And that had been something that Judge Leon had clearly reserved back in 2023. And then they weren't moving with respect to the chat because it didn't occur to them that had been excluded. And then when the district judge sua sponte says we're excluding that, you know, one way to read the record is that's really the straw that breaks the camel's back. And they realize it's not clear they can even present a case with the degree of exclusion that Judge Leon thinks he originally made, but is now clearly communicating that he's making.
Well, Why
doesn't that affect the timeliness?
He clearly, several reasons. First of all, they waited a year and a half to file something about that. But there's still, you've heard no excuse for why the September 2023 ruling was not appealed. Absolutely not. There's nothing in the record, even though they say them. So that when the judge reviews them, he's thinking these are the same motions. And as the government confirmed for him, these are the same motions. I already ruled on this. I've told you, you can't get in anything about the prior conviction. And now you're trying to get in things about the prior conviction. I also think that there's a major flaw in that reasoning, and that the cases set out at page 25 of our brief talk about how you can't do this piecemeal. And you got to remember, as Judge Wilkins asked about intrinsic or extrinsic, they never said. They always filed these motions under 404B and 414. They did not file them as intrinsic evidence of the crime. So the district court, in viewing them under 404B and 414, was absolutely correct, led to that by the government's titling of the motions and the arguments made. But you can't, as the cases say, attempt to resurrect a motion by filing it under new garb, or as then Justice Gorsuch said, There's no reason, this is to me the crucial question. There's no reason why it could not have raised these points earlier in the proceedings. We're talking just before trial, the government didn't even give the district court a heads up that it was going to be filing a notice of appeal. So 55 jurors show up only to find out a notice of appeal has been filed, with even though the parties were in court the day previously. But as Justice Gorsuch said, there's no reason why it could not have raised these points earlier in the proceedings, even during the pendency of the original motion. These facts were all known to the government from the beginning of the case. These were not new facts. But they just chose not to raise them before this, and that it violates the wording and the purpose of 3731. And Judge Pillard, I think that the question about the new counsel, first of all, this is almost a year and a half after the new counsel was appointed. They gave no indication of when he supposedly said this. Second of all, if you read the transcript, even the government said at that hearing that they understood at the appendix 329, the government said it understood that the case may be in a bit of a flux. They clearly were, when the defense lawyer was trying to explain whether identity was an issue or not, he was all over the place, the first lawyer and the second lawyer. But the government had always contended that identity was going to be the defense and that they needed this evidence for identity and intent. And yet neither one of the defense lawyers, when questioned about it, said that that was going to be the defense. He used words like probably and possibly and maybe and that we haven't decided. And so then even the government says, we understand this is in flux. So there was no new facts in any of these motions.
Let me ask you about on the merits. So do you agree that where Rule 414 applies, there's not the same categorical bar against the government using a defendant's prior conduct to prove the defendant's propensity to commit the type of crime before the court? Yes, subject to 403 balancing, but the permissibility or not, the presumptive permissibility or not of propensity evidence is flipped from the ordinary rule 404 once 414 comes into play.
I agree that was Congress's purpose as to admissibility, but they left it exactly the same with respect to the 403 analysis. They made it subject to the 403.
But propensity is on the other side.
Propensity is figured. Well, propensity is a reason to exclude it, period. And then that's an admissibility. I understand what you're saying. It's also because it's now admissible, but it's factored in somehow. But not, to me, the government's argument, it's never a grave abuse of discretion to admit evidence, and it's always a grave abuse of discretion to exclude evidence is essentially
I don't think that's quite fair to the government. I don't think the government's fighting, and we can hear from the government on rebuttal, but I don't think they're fighting the notion that it is still necessary to do a 403 balancing.
Oh, no, I didn't mean to, but I think they come down on the fact that a 403 balancing always is in favor of they said in their argument, it's not an abuse in admitting evidence. They didn't say anything about excluding evidence. The point, yes, propensity is not admissible for propensity evidence under the regular rule 404. It is under 414, but it's still subject to the same prejudice balancing test under 403. And that's where Judge Leon said, I think this evidence is just so prejudicial if the jury hears this and what happened at the prior offense and what took place. And it's just going to be way too hard for them to put that, to judge fairly. He was just trying to give Mr. Zobel a fair trial is all that was really going on. And he said that he did not think that this evidence was that he would get a fair trial because this evidence was so prejudicial. in the case, and that he thought a limiting instruction would not be sufficient. And the government did not challenge that after he said that. And the government also said, also, I think you have to take into account, Judge Leon said from the very beginning that if through either Mr. Zobel testified or through cross-examination of witnesses, identity became the issue in the case, that he would absolutely reassess his ruling and likely admit the evidence the government was trying to keep out. That, to me, is a judge trying to be careful and a perfectly reasonable decision to make, to not let the evidence just come in originally before you know what the defense is or if the defense is going to challenge it.
But what you're talking about is like things could change if identity becomes an issue. That's what he says back in September of 2023, right? So in February and March of 25, isn't it apparent at that point that identity is likely to become an issue? And so doesn't the district court kind of stand firm and say it's not coming in, even though identity is likely to be an issue?
Two things. I don't think it was clear at all that identity was going to be the issue, because both the original defense lawyer and the new defense lawyer kept saying, we're not sure what the defense is going to be. And I'm not sure.
But come on. I mean, we weren't born yesterday. I mean, he's not going to admit that this phone is his. He's not going to concede. The defense lawyer is not going to stand up in opening statement and say, yeah, that was Mr. Zobel's phone, but somebody else used it, or that was him on those chats, but he didn't really mean it. I mean, that's not what the defense is going to be. The defense is going to be they can't prove that it's his phone, or even if they could, they can't prove that he sent those messages.
I mean, that's very similar to what the defense was in the Liu case that Judge Katsas wrote the opinion that it was fantasy and not real, these chats. But the second thing is, they said they were not going to stipulate that the phone was his, but he also didn't say that they were going to. There's a difference between a defense lawyer stipulating that a piece of evidence and letting the evidence in and not challenging it. So I don't think it was clear at all that what the defense was going to be at that point. And for whatever reason, I mean, Judge Leon didn't press them on it, and the government admitted, as they said, it's in a state of flux. And so I don't think the government knew what the defense was going to be. So
But isn't that, I mean, it's basically saying that the government has to wait until jeopardy has attached and see what the district judge is going to do. And therefore there really is no opportunity to appeal, because this is so contextual, and the district judge is just, as you say, being careful and waiting to see what his ruling is going to be. Doesn't that?
No, there was plenty of opportunity to appeal. September 2023, the district judge issued the original ruling. The government,
subject to identity defense. And then you have, is it Mr. Guillaume being very cagey about whether there's going to be an identity defense, and in the end saying, yeah, in some way we're gonna object.
I think he said like it's a probability of a possibility, or I forget his exact language. It was quite hedging, let me put it that way. But the September 2023 ruling was clear, discreet, and could have been appealed at that point.
With a big loophole, whether identity was going to be an issue.
But that's not a loophole. They could appeal and say it's admissible on our case in chief, which is exactly what they're arguing here. There's no loophole there. They're just didn't appeal for whatever reason.
But even if they had appealed then, they would only really be appealing the ruling with respect to excluding the proffer, right? Because there's no indication that the testimony about the case agent and probation officer is going to be excluded, or or the testimony about, or the evidence of the chats is going to be excluded?
So the case, yes, they had not raised that yet, but that's what is specifically why the cases at page 25 say that they shouldn't be allowed to do that, to piecemeal file motions and then keep renewing the time to file a notice of appeal.
But I guess what I'm saying is then if your jurisdictional argument has merit, it's merit with respect to we don't have jurisdiction to hear the appeal of the exclusion to plea proffer, but we do have jurisdiction as to everything else.
No, I think it's everything because they should have included everything in that original motion. It was all right there available to them, and they chose not to give Judge Leon a chance to rule on that along with the plea colloquy evidence. And you have to remember, they were trying to introduce the entire plea colloquy at that point. And the fact that there's some kind of gamesmanship going on at the March 17th hearing, the day before trial was supposed to start, the government said to Judge Leon, I just want to make sure we're clear about the prior ruling. The plea colloquy from his prior conviction would also be excluded as well, correct? That was clear almost 2 years before that ruling. And Judge Leon actually got upset and asked them if they were playing games and why they were doing things like that. So all this evidence was in the possession of the government, known to the government, and intended to be introduced by the government. But if they were trying to piecemeal the rulings by the district court, that 3731 doesn't allow that. That's the whole purpose of 3731 is to prevent that. And well, not to prevent it, but part of the reasoning for 3731 is to get issues like that decided so that the government can't keep filing motions and adding things and then saying that extends our time to appeal. I do agree with you, though, that absolutely the government stood up here and said the only possible legal error was the propensity evidence, the treatment of propensity evidence in September 2023, that the plea colloquy is absolutely too late. They can't just, they filed an identical motion almost 2 years later with the exact same wording in it about it. So that one clearly is barred. The others are barred because they can't divide things into piecemeal and keep trying to file motions in front of the district court. And then as far as the grave abuse of discretion, first of all, the government mentions grave abuse once in its brief in passing and never again. It's a grave abuse standard, and the government simply disagrees. I don't agree with the government at all that the judge made a legal error in September of 2023. But so putting that aside, the district judge, under the facts of this case, he reviewed very carefully. He also, again, ignored by the government in their argument, he also went through a whole series of items of proof that the government had, apart from all this evidence, that would lead, he called overwhelming at one point, that would lead to conviction. And he also always promised that if the defense got up there either direct or through cross-examination and raised the defense of identity, that it would come in. But so all of this is, there's no grave abuse of discretion. This court has been quite clear that it's a very high hurdle to meet.
Standard of review is a strong point for you, but put that aside. Let's just focus on the substantive standard under 403. Is there any respect in which the case for exclusion here is stronger than the case was for exclusion in lieu?
Well, I think it's a couple
because lieu was, the government put on a live victim who testified to the details of abuse, uncharged acts of abuse, and that came in.
Well, let me just preface it with something that you probably thought I shouldn't say, which is that doesn't mean it's a grave abuse of
that.
discretion for a different judge
trying
in a
to-
different case to reach a different result.
I'm trying to figure out if you have anything besides standard of review.
Well, with respect to the probation officer's testimony that they won, Judge Leon decided to admit it, but he just wouldn't let the person be identified as a probation officer. So
The attempt to excise any reference to the uncharged acts.
because he thought that they were too prejudicial in this case.
No, I'm saying,
No,
is it on substance as opposed to standard of review? Is it consistent with Lou to try to exclude all and any references to the other acts here?
Lou was just, I think, said that the way it was presented was proper. It didn't say that if somebody tried to sanitize it better so it would be less prejudicial, that would be improper. It doesn't say that at all. It doesn't say that that's the only way it can be done. So when the district court here tried to get the probation officer's testimony, and I don't think there's anything that a jury would question that somebody goes once a month, a landlord or a apartment manager goes once a month to inspect the premises, that there would be any question of why are they doing that. The district court also let in testimony about a 16-year-old and a 12-year-old that that were also
Focus on the chats.
on the chats. Well,
And it's part and parcel of how this offense is being committed.
well, I guess I could say that
And even other acts evidence, and yet he's still trying to exclude any reference.
he's trying to exclude any reference as long as the defense doesn't in cross-examination or direct testimony challenged identity. So, but the government admitted that they can do this, and I understand that was about the plea colloquy, but it's the same thing. Judge Leon was trying to impress upon the government that he didn't want any mention of the prior conviction unless and until the defense made that relevant, which seems to me not on an abuse of discretion, but perfectly.
Defense makes it, I mean, we're loosely using the word defense, but these are elements of the government's.
Well, but they weren't presented that way. They were presented.
Government has to prove that Zobel, who's
Right.
on my mind, Zobel sent the chats and that he intended for the undercover officer to actually go through with the abuse.
And the district court thought that there was abundant evidence aside from having to do with a prior conviction of that. And he not only did he do that, he laid out 6 specific items, including the watch
on identity.
worn by the.
On identity.
Yes. And he said that the government did.
Their case on intent is more compelling for what that's worth.
Well, what the district judge said there, that the government didn't contest, is anybody who reads these chats would understand that the intent is there. The government didn't dispute that.
Maybe, but I mean, the most compelling evidence is the guy is advertising himself as a convicted offender.
But they're not having the evidence be the most compelling if the court finds that 403 would not admit it, doesn't mean that it's automatically admissible. That's the issue, I think.
Well, it's not automatically, but let me just ask, I had asked you previously about this. The way I understand 414 is that it shifts propensity evidence from a very strong presumption that it's inadmissible. It's inadmissible for propensity, and it's only admissible if it goes to these other topics, to putting it on the other side of the 403 ledger. It is relevant. Nothing bars it from being introduced. So it's presumptively admissible unless there is undue prejudice. And I think one of the things that Judge Katsas and I have been probing on, and Judge Wilkins also, isn't it highly probative? And the prejudice is not unfair prejudice, but prejudice going to this offense, going to prove a grave offense, that he says, look, I'm for real. You can trust I'm not a cop, and this is why.
But the district court thought that the way the government, you got to remember, the government never, they claimed in the third motion they filed that they wanted to somehow make it less offensive, so to speak. But then they filed a motion 3 weeks later that went right back to the original and said, no, we want to get everything in. And Judge Leon, I think, made the reasonable decision that given the circumstances of the prior, which involved, they wanted to get in evidence, both that he had sex with the facts of the plea, and that they were extremely prejudicial because he had forced. It said in that he had forced two younger girls into sex acts, that he had sex, and Judge Leon let in a part about the 16-year-old later, but and that also he had distributed child pornography. That was also part of the colloquy they wanted to get in, and he thought that was too specific. And
let me go back. Do you agree with me that 414 makes the propensity character of the prior bad acts evidence probative? It's not probative qua propensity under, without 414. It's excluded under 404. But once you have 414, it is presumptively in. Presumptively.
when you say in, I think
It's
that may
presumptively probative. Probative. It's permissible inference, presumptively.
yes, but when you say in, I think presumptively admissible.
Yeah.
But subject to
404 balancing.
Yes.
I just wanted to
Yes.
clarify.
No, I agree. That was the purpose of
Let
414.
me try it this way. The propensity inference itself cannot qualify as being unfairly prejudicial, even though salacious details and stuff might be.
I'm not sure I go that far. I understand
Why not?
it's admissible it's admissible. The question is, though, then is it subject to the prejudicial test? And just the fact that it's admissible,
Unfair prejudice.
yes, it substantially outweighed the prejudicial value substantially outweighs the probative value. The fact that otherwise there would be no reason to subject it to 403 analysis, because the Congress could have
There are all
said.
there are all sorts of reasons above and beyond the propensity inference. It could be cumulative. It could have some salacious detail that you can easily excise that would inflame the jury as opposed to just supporting the permissible inference.
And that's
as a pedophile, that makes it more likely that he would have committed this offense.
And that what you just said is exactly why Judge Leon kept it out, the salacious details of it in the plea colloquy.
He kept out any reference.
Well, that's because they didn't offer any alternative. The government never offered an alternative.
Okay, that's fair.
Yeah.
But
What if they had offered something saying, here is what the person on the chats was asking the undercover to perform with an underage girl and describing it. And then if the government said, we want to put in a summary of a plea, the defendant pled guilty to that same conduct with girls age 12 and 13, period.
So I think you run into the dilemma of propensity evidence is extremely powerful evidence, no question, but it's also probably the most prejudicial evidence of all. So yes, is it admissible? Yes. But is it just on the plain admissibility issue? But is it more prejudicial than not in a particular case? That's a decision for the district judge to make.
Yeah, okay. I mean, I heard your answer, but I think that, so that's a legal question before us.
And I agree that it can't be kept out just for the propensity, but it's a factor.
I'm trying to probe because it seems to me you are saying that if the propensity, qua propensity is powerful enough, and this is an interesting case on this because it really does match the offense conduct with which the defendant is charged pretty closely. You're making a skeptical case, but to the extent that as Judge Katsas pointed out, one of the things Congress is concerned about is different rates of recidivism in pedophilia, and wanting to be able to say because of that, the data on that and the experience on that the rule makers are thinking about, or the Congress is thinking about, they move propensity from the impermissible side of the ledger to the permissible side. And so they're saying that the propensity inference as such isn't unfairly prejudicial. In fact, it's probative.
You mean alone when you say as such.
Alone.
But there was other factors
No,
here.
but that's why I'm asking whether you believe that and trying to come up with a sanitized version of the prior crime that really leaves all that's left is propensity, but propensity to do this thing that matches. And I guess I'm asking you, I mean, we can't maybe wordsmith it, but if the government had proposed, we want to show prior crime, and we want to make clear we're not going to amp up how grotesque and repellent it is. We're just going to say it matches in really material respects the thing that the person on the chats is asking the undercover to perform.
So a couple of things.
Is that unfairly prejudicial?
So I think two things. That's not when I had the skeptical face, Judge Leon said this is completely different conduct in the prior. The government did not contest that the conduct in the prior was different than Mr. Zobel is charged with currently. And the second,
well, he said different. It's completely different because Zobel's just doing things online. The charge defense is just online.
right.
It's completely similar with regard to the age of the victims and the particular sex acts involved.
Just with respect to count 3.
Yes.
That's all we're talking
Yes.
about.
What Zobel admits to have done to two young girls, and what Zobel is charged with wanting the undercover agent to do to his purported.
And the second thing, the second part of what I wanted to say, I think, is that the government didn't argue that below. And second thing, they presented it as 404B and 414 in their motion. So I don't think you can blame the district court for this extrinsic analysis because it was presented by way of 404 and 414 to the district court.
And how should they have?
They could have just said this is part of the offense.
Nobody disputes that the evidence, the government wants this to show motive or intent, a permissible use under 404B, and propensity, which we think is a permissible inference under 414. This only comes up when you get to the back end of the analysis, which is the 403 balancing.
Right.
Which was contested.
I mean, Judge Leon said it was admissible. There was he said this is admissible evidence under 404 and 414. Again, the government, and when he said, I want to excise the part about the prior convictions, the government didn't really, I mean, I understood they wanted them in, but they didn't say, well, that's unfair to us or it's extrinsic. They said they understood actually at one point that this was consistent with his ruling, that he didn't want anything about the prior conviction to come into evidence. So, I mean, I think a lot of this is due to the way the government presented it to court, besides which the improper, they've never explained why they didn't appeal the September 2023 motion. But other than that, thank you.
Thank you, Mr. Kramer. And we'll hear rebuttal if you have it, Mr. Coleman. Why no motion in limine about the chats?
So the government isn't normally required to move to admit its evidence. I mean, it is prudent for the government to move to admit things like other crimes evidence specifically. In other words, something like the plea proffer, because if it gets excluded during trial, then it won't be able to appeal. But there's generally no requirement for the government to move to introduce evidence of the crime. I guess I just haven't seen us ever have to do that. I do think, in responding to my opponent here, I think his arguments consistently sort of blur the line between the plea proffer details that the government did move prudently and in accordance with normal practice to try to, make sure it got a pretrial ruling, and the actual, offense conduct, which normally the government doesn't have to move in limine to introduce. Moving to the question of how to take into account what 414 permits, namely the propensity inference and Rule 403. I think, the words of the Eighth Circuit in the case of US v. Lecomte, which we cited in our brief, which says Rule 403 has to be applied to allow Rule 404 to have its intended effect. I think, again.
414?
414, yes, to have its intended effect, which is namely that, yes, the propensity inference in child sex abuse cases is no longer unfair prejudice. So it doesn't fall on the unfair prejudice side of what Rule 403 requires to be weighed. So again, I mean, I think that, that is a major change. And so, it does make it, Congress intended to make it much harder for district courts to exclude this evidence. I do think it's important to note that the government did try to sanitize the evidence from the old case. There's the plea proffer details. At the preliminary hearing, it was clear that there were some, fairly, significant details, such as the fact that Mr. Zobel locked in the two girls to his car and wouldn't let them out before he used them. We never sought to introduce that from the start. The government did in its subsequent motion in limine, after it learned about the ID defense and moved to reconsider, did sanitize it further. I mean, again, we could have discussions with the district court about how to sanitize it, but we never even got to that point because the district court's reaction to the government's motion to reconsider was, not only am I not going to let any of that in, but now we're going to start excluding the offense conduct itself. I do think there was one other.
You say you tried to sanitize it further. Defense keeps saying it was exactly the same. Materially, what was the additional sanitizing?
Okay, so in the original plea proffer summary that we sought to admit, this was back in 2023, the government said that it was going to add, that it would try to admit the fact that Mr. Zobel had made the first girl, the 13-year-old girl, perform oral sex on him in January 2009. And then when he picked up the girl and her 12-year-old friend in June 2009, made them perform oral sex on him. We just said sexual acts, so we weren't as specific. Now, again, here, if we're going to line up what he was asking the undercover officer in this case to do, he wanted to have the undercover officer have the girl, the putative daughter, perform oral sex on the undercover officer. So, I mean, there was, in fact, a fairly close alignment between what he had done to the girls himself and what he wanted the undercover officer to do. But again, those discussions, we never even got to that point because the district court again, after never indicating originally that it was going to exclude the chat evidence, its reaction to the motion to reconsider is to start including even more evidence. The only final point that I did want to respond to was with respect to sort of, the question of whether the government had an earlier point in time knew that ID was the defense. I can't say it's not in the record, but there's a reason why the defense counsel doesn't say in February, at the hearing in February of 2025, we told them about the ID defense before then. I do know that that intention to raise identity as a defense was communicated to the government a week before it filed its motion to reconsider on February 21st. That's not in the record, but if there is a question here, that we did not sit on this for 6 months or a year. If there are no further questions, we respectfully ask that the judgment of the district court be reversed. Thank you.
Thank you. The case is submitted.
Case number 24-5243, Jawan and Tarquini appellate versus John Phelan, Secretary, U.S. Department of the Navy. Ms. Tarquini for the appellant, Mr. Harris for amicus curiae for appellant, and Mr. Sampat for the appellee.
All right, you may approach and begin when you're ready. Good morning.
Good morning. Good morning, Your Honors. May it please the court. My name is Jawan Tarquini, and I am the appellate appearing pro se. The district court granted summary judgment without examining whether the process that led to my termination was constitutionally sound. The record shows it was not. In July 2014, I reported discriminatory treatment and hiring violations against Carlos Saldana and his HR office in Okinawa, Japan. No one ever investigated my complaints. 14 months later, Saldana was assigned to investigate me for the same type of hiring violations I reported against him. At the close of that investigation, Lieutenant Colonel Scott Manning signed a document on October 30th, 2015, concluding I was guilty based on that investigation that Saldana conducted. That document, along with the complete file, was withheld from me. As a disabled veteran, I was immediately removed and barred from the base overseas with no access to medical care. 2 weeks later, Manning, who had already concluded I was guilty, supervised my only access to the evidence against me. It was time-limited partial review of a partial file with no copies allowed inside of a police station under armed guard. Manning and Saldana then directed and advised Colonel Boucher, who decided my appeal. My first-line supervisor, Robert Johnston, proposed a termination, citing a hiring violation, issued me paperwork immediately to out-process from the base, and then publicly gave me a professional endorsement that exact same night. During the termination meeting, he was in tears, and he told me 5 times that I didn't deserve it, that he was forced, and that I should fight it. Manning was present at that meeting as well. John Iwanek, my second-line supervisor, signed my termination, changing the reason from hiring violation to employment misconduct. Then he gave me a glowing reference to the Department of Justice U.S. Attorney's Office. He testified that he had no reason but to give me a positive review. Ironic. The reasons for my termination shifted multiple times across multiple documents, from hiring to employment to poor performance to involvement in a process the government's own attorney, Jody Devine, admitted was within policy. In 2024, nearly 10 years later, I finally received the complete investigative file that they relied on in 2015 to terminate me. The staffing specialist who actually performed the work testified clearly that the directions came from Cheryl Harkness, who was under the exact same investigation for the same conduct, not from me. The investigation file does not just fail to prove what they accuse me of, it proves the opposite, that I wasn't involved. Colonel Boucher, the official who decided my appeal, testified that he remembered no evidence except the one statement from Cheryl Harkness. I never saw the statement and I never got to question her. Boucher's own decision letter cited employment misconduct regarding both my husband and my brother as his basis for termination. But when he testified, he said that the decision was about hiring, non-employment misconduct at all, hiring. So when asked about my brother, Boucher said, "I'm guessing now, so I don't know." My brother was included in the charges to create like an appearance of a pattern, but Boucher could not remember a single piece of evidence to support it because there was none. The district court affirmed summary judgment in a process that was riddled with contradictions, ex parte communications, shifting charges with no notice or clear opportunity to respond, conflicted advisors, and a decision resting entirely on a statement from a witness who was under the investigation for the same conduct. Manning and Saldana had already concluded I was guilty. Boucher depended entirely on their direct counsel and direction. So the outcome was decided before it even reached his desk. There was no neutral process, and that is what I'm asking this court to correct. Thank you.
Mr. Tarquini, the Inspector General's report is the reason that your former employer gave for the discharge, but your case before us is a case of employment discrimination. The deciding officials, Mr. Johnson and Mr. Jawan, in the record, they say they relied on the Inspector General's report to make the decision that they needed to terminate your employment. Can you point us to anything in the record that shows they did not actually believe in the validity of they didn't believe in the validity of the Inspector General's conclusions?
Yes. So the day of termination, I was corresponding with headquarters and informing them of everything that was going on and everything that was happening contemporaneously. And I let the headquarters know, the director there, Dennis Ray, that my supervisor, Robert Johnson, was crying multiple times. He said that I did not deserve it. He said that it was not fair and that I should fight it. In further speaking with him, he said that Mr. Iwanek thought the same thing, that I did not deserve it, that I should fight it, and that it was not warranted. Then Mr. Johnston came and he gave me the reference that same night, that positive reference. And then Mr. Iwanek gave me a positive reference to a promotion after that. So if they honestly believe that I created misconduct, then they would not have referred me as adamantly that they did after the fact. And as far as the investigatory file, I was only given a partial review of that. I didn't see the entire file until almost 10 years later. So the file that they so-called were using to support the investigation, I didn't get a copy and I didn't see it myself for almost 10 years later. I only had parts of the file over the course of 10 years that I did not receive. And that's what they said that they depended on the day that they terminated me. I didn't have access and I had no idea that any of that other file even existed until 2024.
But I think that I heard you say, I want to make sure that I understand you correctly, that if one looks at that file, one would find that it does not substantiate the grounds for the termination. Is that what you said earlier?
That is correct.
And why is that? Direct me to what if I were to read that file, what should I look for that would say that this is a sham?
That's an excellent question because I still don't know to this day the reason of the termination as stated in the termination documentation. So for example, Mr. Iwanek on the termination letter, he says that it's in reference to references that it's at the top of that termination document itself, but it doesn't list what those references are. It doesn't list anything. So I don't know what inside of that specific document that they were referencing. All I do know is that when I finally did receive the documents and I saw the whole file, inside of the document itself, there is a testimony and a statement from Kayori Yakahari, who was the staffing specialist who actually performed the duties. She testified and she stated very clearly that the direction came directly from Cheryl Harkness, who was also underneath that exact same investigation, not from me. So that's their own investigation that says very clearly where the direction came from, which has nothing at all to do with me. So that's in their investigation specifically.
All right. And you have counsel for amicus who's agreed to argue on your behalf.
Yes.
If you want to, have you reserved time for rebuttal? Or?
Yes, I did.
Right. So from you after we hear from defendant, but we'll hear now from amicus.
Morning, Your Honors. Ben Harris is the court-appointed amicus in support of the appellant, and I'd like to reserve 2 minutes for rebuttal. The district court committed 2 fundamental errors, each of which warrants reversal. First, the district court failed to analyze whether Tarquini could prevail under a motivating factor theory of discrimination, which provides for liability under Title VII, even where other factors motivated an adverse employment action. There's voluminous record evidence showing discriminatory animus by the key decision makers in this case, Johnston and Awanak, and that is enough to get past summary judgment under a motivating factor theory. Second, the district court committed fundamental errors in analyzing the but-for causation theory of liability. Specifically, the court held Tarquini to an impermissibly high standard and failed to recognize what this court said in Ponce, that there could be multiple but-for causes of a given event. And the court wrongly discounted evidence of discrimination as isolated and occurring a significant time before Tarquini's termination. The record flatly contradicts that reasoning, and this court should reverse. I'd like to start, Your Honors, with the motivating factor theory of discrimination. The government's primary argument is that Tarquini waived or forfeited that argument by failing to present it to the district court. I think there are a few reasons why this court should reject that waiver or forfeiture argument. The first is that if you look at Tarquini's summary judgment briefing, she specifically invoked discrimination as an animating rationale for the adverse employment action. That's at JA 567 to 570. And in her declaration as part of summary judgment at JA 654, Tarquini explained that it was due to discrimination and bias against her on account of her race and her sex, among other things, that the Navy terminated her employment. Now, I think that's enough at summary judgment by a pro se litigant to make the district court aware of the causal connection between discrimination and an adverse employment action. If you look at the statute, subsection A says that when discrimination or race or sex is a cause of an adverse employment action, that's an unlawful employment practice. But subsection M says that it is an unlawful employment practice when a motivating factor plays a part in an adverse employment action. Well, what the statute is saying is that to meet that causation element, you can advance a motivating factor theory of liability. So the district court was aware that Tarquini was arguing a causal connection, and a motivating factor theory of liability is a lesser evidentiary burden to show liability under Title VII. By arguing pretext in her summary judgment briefing, Tarquini necessarily advanced the theory that race or sex was a motivating factor.
That's an argument that any summary judgment motion will encompass both theories.
I think under ordinary circumstances, Your Honor, when a litigant is saying race or sex caused my adverse employment action, caused my firing, a subsidiary argument there is that race or sex was a motivating factor. It contributed to the firing. Now, the but-for causation standard theory, and this is what the Supreme Court says in Bostic, it's a greater evidentiary showing, and it can get you additional relief down the line at trial.
I mean, maybe as a matter of spitballing, but it's just hard to reconcile with how Title VII cases are litigated. These are very distinct theories of liability.
This court said in Fogg, Your Honor, that a plaintiff pursuing a Title VII claim can, of course, use evidence of pretext in the McDonnell-Douglas framework to show that race or sex or any other impermissible characteristic was one motivating factor contributing to an adverse employment action. So I think in practice, what you're asking at summary judgment is, can the plaintiff, could a reasonable fact finder find liability under Title VII? And the statute clearly articulates that a motivating factor theory of discrimination gets you to liability. It's just a lesser evidentiary showing than a but-for cause of liability.
So, but I'm going to assume for the moment that you're not saying that any litigant, counseled or not, who raises a but-for claim under subsection A should be presumed necessarily to have raised a motivating factor claim under M. I take you to be saying that we have a pro se litigant here and that the district court, therefore, looking at this evidence in this case, should have also analyzed motivating factor. Is that correct or no?
That's right, Your Honor. I don't think the court needs to articulate a hard and fast rule that applies to every litigant. And I think Your Honor is exactly right. We have a pro se litigant. She put forward in her summary judgment briefing that discrimination was a cause of her adverse employment action. She specifically invoked discrimination multiple times in the record at summary judgment, and she didn't expressly disclaim a motivating factor theory of liability. In fact, she didn't clearly pursue either route of liability.
She just argued discrimination was a cause and, you know, or an element was behind the action. But I'm trying to understand why the district court would have had to go through that in this case, precisely because she's pro se. It seems to me the big benefit of finding of a motivating factor, at least, and not if but-for cause is not supported, which is what the district court thought, why would this district court in this case go on to say, but discrimination was a motivating factor where there's no attorney's fees that can be won. There's, any declaratory relief would not sort of clean off her record in regard to the reliance on the Inspector General report. There's no back pay or compensatory punitive damages available under a pure motivating factor analysis. So why would it be incumbent on the district court in a case like this to also consider that alternative argument?
Well, Tarquini asked for various forms of relief in her initial complaint. This is a J19 to 20, including appropriate injunctive and equitable relief. And it's possible that even under a motivating factor theory, she could get a declaration that she was the subject of unlawful employment discrimination. B, she could get some form of injunctive relief. It might look like training for her former supervisors. It might look like a letter explaining what happened to future employers. There may be certain kinds of relief available to even a pro se litigant, and even on this complaint and in this case, under the specific relief that Tarquini asked for. And I think this question gets to the purpose of subsection M. I mean, what the Supreme Court said in Price Waterhouse is that once you can show that the employer would have taken the adverse employment action anyway, that's a complete defense to liability. And Congress undercuts Price Waterhouse and says no in 1991. It adds subsection M, and it says illegal employment discrimination is a problem, which is why even where race or sex or another impermissible characteristic plays even a small part in an adverse employment action, that is illegal under Title VII. And that's part of the purpose of the motivating factor theory of discrimination, to vindicate a plaintiff's rights under Title VII and to ensure that workplaces, especially workplaces controlled by the United States government, are free from illegal discrimination.
On the but-for causation, the district court said that there's not enough evidence to send to a jury on that. And in particular, that there really isn't a nexus between the kinds of sex-based comments and differential treatment based on race and sex that Ms. Tarquini puts in evidence. And what's your response? You argue that but-for causation should have been sent to the jury.
I think there are a few fundamental errors with the district court's reasoning as to but-for causation. And the first two relate to how the district court characterized the evidence in this case. The district court didn't catalog or explain the evidence, the voluminous evidence of discriminatory animus by the two decision makers, and instead it characterized the remarks as quote unquote isolated and occurring a significant time before the adverse employment action. I think the record directly contradicts both of those rationales. First of all, the evidence was voluminous. It showed discriminatory comments and conduct occurring throughout the time of Tarquini's employment up and through November of 2015. Comments relating to her being bossy, emotional in the workplace, comments by both supervisors asking Tarquini whether it was quote unquote that time of month, comments relating to her weight and her appearance, making Tarquini apologize to her white counterparts, comments that Tarquini was bossy at a company picnic. I mean, these are comments that are occurring throughout the time of Tarquini's employment and are not isolated or stray remarks.
I thought that in a way, the most clearly sex-based were the that time of month comments, which then in context relate to the bossy and emotional comments. Did she press those before the district court? Because it struck me the district court did not mention, I'm not recalling the district court having mentioned those comments in its opinion.
You're right, Judge Peller, that the district court didn't mention the comments, but Tarquini did put the comments in her summary judgment briefing and explained to the district court that she was subject to sex and race-based discrimination, referring to the comments and conduct that she then elaborates on in her declaration in support of summary judgment. So the district court is on notice that all of these comments and conduct happened during the course of her employment. She's referencing that in her summary judgment briefing and in the declaration. But you're right, the district court does not catalog those comments or acknowledge that they happened. It characterizes them as isolated, which they were not, and it characterizes them as occurring a significant time before the adverse employment action. But there are comments and conduct occurring up through November of 2015. For instance, J627 in October of 2015, a month before the termination, Johnston told Tarquini she was too bossy at a company picnic. Between April 2014 to November 2015, the same month when Tarquini is terminated, her bosses treated her as inferior to her white counterparts when she had done nothing wrong and treated her as subservient. That's J606.
Do you have any more specifics on that?
There are more specifics in the declaration, Your Honor. I mean, there are at J606 through November 2015, quote, I was frequently instructed by Mr. Johnston to alter my tone, appear less emotional in conversations with others, and to avoid acting as if it was that time of month. That's through November of 2015. So if we're talking about the district court's analysis under the but-for causation theory of a nexus between the discriminatory comments and the adverse employment action, the two primary bases the district court invoked, isolated and occurring a significant time before the adverse employment action, don't stand up to the record evidence summary judgment.
And do Mr. Jawan or Mr. Johnson deny ever having said anything about that time of month or ever having described her as too emotional or too bossy?
They do. In their deposition transcripts, they deny having made the comments. Now, of course, the court views the evidence in summary judgment in a light most favorable to Tarquini, and that's a classic question for the fact finder, whether those comments were actually made, whether they engaged in that kind of conduct, and who's to be believed.
You don't have citations where they deny that either.
I don't, Your Honor, but I can address them on rebuttal where they deny doing that. I think the other error to highlight as part of the but-for causation analysis is the district court's conclusion that none of the comparators had supervised. Well, the district court said two of the comparators had the same supervisors as Tarquini, but it ignored the evidence as to Gary Holsopple. And I think that's relevant comparator evidence in summary judgment. Tarquini alleges that Holsopple engaged in misconduct and covered up sexual assault allegations in the workplace, yet was not fired. The district court appears to assume that Awanak and Johnston didn't supervise Gary Holsopple, but JA 206 has the organization chart for MCCS. And it shows that Holsapple was directly under their supervision. So that's just another error looking at the factual record that appears to have animated the district court's nexus analysis under but-for causation.
Do you have anything to add to what Ms. Tarquini said about why a reasonable fact finder could find that the decision makers didn't believe the Inspector General report?
As far as I can tell from looking at the record, Your Honor, I don't have anything to add to Ms. Tarquini's argument about that. But I think what's important to understand is that in a motivating factor theory of discrimination, it is not on a Title VII plaintiff to disclaim or disprove the employer's non-discriminatory rationale for an adverse employment action. So
I'm talking about if with respect to the but-for argument or the pretext argument.
I would say the same thing is true even in a but-for case, Your Honor. I mean, this court acknowledged in Ponce, the Supreme Court said in Bostick, there could be multiple but-for causes of a given event. And this court said in Holcomb, a Title VII plaintiff has multiple routes to liability. One is disproving or casting doubt on an employer's non-discriminatory rationale, but a plaintiff can also offer other evidence of intentional discrimination. And it's entirely possible that there could be two but-for causes of a termination. There could be a non-discriminatory reason that stems from an investigation or some report of wrongdoing, and race or sex or another impermissible consideration could also be a but-for cause.
I appreciate that as a description of the doctrine, but as applied in this case, I'm not sure that I have at my fingertips the narrative of how both could be a but-for cause. If Ms. Tarquini had not been a Black woman, but this IG report had come out about that man's conduct, he would not have been fired. What evidence do we have that would raise a jury issue with respect to your more than one but-for cause approach?
I think the record shows that there were a range of options available to the key decision makers in this case, and that the investigative report didn't inevitably lead to Tarquini's firing. And I think it's important to understand this because it really shows how race or sex could be a but-for cause. At JA 207 to 221, that's the manual that announces the Navy's policy about first-time offenses, termination. There's a range of options for first-time offenses. It goes from reprimand on the one end of the spectrum to termination on the other. And the investigative report in this case.
What page was that? I'm sorry.
That was JA 207 to 221, Judge Wilkins. And the investigative report in this case did not recommend a specific action. At JA 1421, the report forwarded to Johnston and Awanak, quote, for consideration and appropriate action. And if you turn to their explanations for why they fired Tarquini, they did not rely solely on that investigative report. What Awanak says in his declaration at JA 314 is that he read the investigative report very carefully, but did not terminate Tarquini based solely on the IG's conclusions. He said, quote, I made my own determinations based on the evidence that the IG had collected, as well as my own knowledge of Mrs. Tarquini's actions. And at JA 2156, which is MCCS's letter in response to Tarquini's internal appeal to Colonel Boucher.
You said 426?
Sorry, this is JA 2156. I may have misspoken.
No, go ahead.
Awanak said he, quote, also considered his personal knowledge of Mrs. Tarquini's actions in the previous year. So the record evidence doesn't show that the investigative report somehow bound Johnston and Awanak to firing Tarquini. In fact, the report gave them a range of options that they could take in response to the findings that were substantiated by Saldana and Hodges. And if it were the case that Awanak and Johnston felt bound to terminate Tarquini based on the report, there would be no explanation for why they considered other factors besides the report in making that final determination. So I think that's what the record shows in terms of what the decision makers were thinking at the time they fired Tarquini. And then I think you add in the comparator evidence in the but-for analysis. And when you have a white male comparator, Gary Holsapple, who is alleged to have been engaged in covering up sexual assault misconduct inside the workplace, supervised by the same key decision makers, and who isn't fired for conduct conduct of a comparable seriousness, that's I think how you get to there's a fact finder could conclude that but for Tarquini's race or sex, she would not have been fired.
You're not pointing to Cheryl Harkness as a comparator. I believe that Ms. Tarquini avers somewhere that she engaged in nepotism but faced no disciplinary action.
Your Honor, the organizational chart, I think, is key there and the key decision makers with respect to Harkness. So that's why I focused on Gary Holsapple. But, I think Holsapple's the best comparator, not necessarily the only comparator, just the one that I highlighted.
All right. Thank you. And did you also reserve time for rebuttal?
I did.
All right. We'll hear now from Mr. Sampat.
Good morning, Your Honors. May it please the court, Truman Sampat on behalf of the Secretary of the Navy. Congress thought nepotism was an evil unto itself, and it codified that evil in statute. The standard of ethical conduct is governed by federal regulations. Ms. Tarquini, as the Chief of Human Resources, decided to upend that theory and upend civil service and offended the very notion of it by engaging in nepotism and influencing the hiring of her husband and her brother. Her conduct was severe enough that it warranted the Office of the Inspector General to investigate the allegations. It substantiated those allegations. Then Mr. Johnston and Mr. Iwanek, as Ms. Tarquini's supervisors, reviewed the report, decided to terminate her because she was the chief of HR. If that is not a legitimate, non-discriminatory reason for her termination, I don't know what is.
What's your response to what Ms. Tarquini said at the podium today, that she didn't have access to full materials until 10 years later, and that looking at them now, it appears that someone else was responsible?
So, Your Honor, the district court rejected those theories based on the facts in the record that showed that Ms. Tarquini had actually reviewed the reports and had information at her fingertips. Obviously, the record, I will admit that not 100% clear with the volume of it, but she did testify, and it's her own statements that say she did review the report. I'll just start with the motivating factor theory very quickly. I know my friend on the other side, my amicus friend on the other side, advanced that theory. I will say it is waived, despite the fact that Ms. Tarquini proceeded pro se below. I think to say that the district
forfeited, not waived.
Oh, sorry, excuse me, forfeited. Yes, I apologize, Your Honor. It is forfeited, given this court's decision in Ponce that puts the burden on an employee to raise that theory at summary judgment. She had an obligation to raise it. She didn't, and it is therefore waived.
We have, and not in this identical context, but in various contexts, we have case law that it is the court's responsibility, even when something is not raised, and particularly by pro se counsel, when they're ruling on the merits, the ultimate merits. I mean, we have cases about the local Rule 7 where motions can be granted as conceded, and we said, no, where that's a dispositive motion. It's the obligation of the court is to get the law right. Why would we not apply a similar analysis here?
So I'm gonna quote the Second Circuit in Davis versus Kelly. I think it aptly points out exactly why. A court need not act as an advocate for pro se litigants. To impose that obligation on district courts to think of theories that a pro se plaintiff may advance would put the district court in the advocacy bucket and not as an independent arbiter of the case before it. This court the courts below have said numerous times that pro se plaintiffs can waive and forfeit arguments if they're not raised. I don't see much difference here. And there was nothing in the summary judgment motion that would have put the district court on notice that Ms. Tarquini was indeed advancing a motivating factor theory.
But we have, for example, in one of the cases, Winston and Strawn versus McLean, which is at 843 F 3rd 503. And if you look at 506 to 507, we hold after the district court says local rule 7 applies, which is that a motion was not contested. So that's a forfeiture, basically. A party has forfeited. And we said, well, no. That the court may only grant summary judgment if there's no genuine issue of material fact in dispute and the movement is entitled to judgment as a matter of law. And panel of this court said these standards cannot be satisfied if the district court simply grants judgment as conceded or as forfeited when the non-moving party fails to meet a deadline. So why doesn't similar analysis apply here to a pro se who hasn't articulated as such? I mean, here she's given the court more to work with than in the typical case of forfeiture. The material is, as you heard Mr. Harris explain, it's really the same bucket of evidence. She's saying discrimination. My firing was affected by discrimination. Why isn't that something that she raised? She didn't say, I'm only raising but for cause, but I'm challenging discrimination.
So, Your Honor, in her opposition to summary judgment, understanding that, she raised that her termination was motivated by animus, but I think Judge Katsas hit the nail on the head during his colloquy with Mr. Harris, which is that, inviting any other rule would effectively turn every opposition to summary judgment as one that court has to consider all the theories and would kind of.
This is a theory that is nested, right within any theory of discrimination in employment. Was it a but-for cause? Was it a motivating factor? I mean, it's not like, oh, does she also have an equal protection claim, or does she also have, a tort claim? It's pretty. This is a uniquely proximate and family in the family of the claim that she. I mean, in fact, maybe this is the main claim that she brought because she doesn't really parse it out separately.
So what I would say, Your Honor, though, is, basic party presentation principles still have to apply. And
she presented evidence of discrimination.
She presented evidence of discrimination and has really put all her eggs in the basket of the but-for theory, saying that the termination is motivated by her membership in a protected class. She's fought the termination through her briefing in the district court. Through here, she's objected to the findings of the IG report. There's nothing in the record that the district court could have read to perceive Ms. Tarquini as even raising.
At the administrative exhaustion stage, does the paperwork there distinguish between but for and motivating factor, mixed motive, like in the paperwork that someone is given as far as exhausting a claim?
So, Your Honor, are you talking about like the formal EEO complaint?
Yes.
I have it, but I don't recall seeing a field or anything of that sort that would say, are you proceeding under before or are you proceeding under mixed motive? And again, we're not disputing that a plaintiff can raise both.
The reason I ask is that it seems to me that if when you're exhausting, there is no requirement to kind of exhaust both or to bring both to the attention at that level. Doesn't that kind of cut against your argument? Because there's no way to know whether she exhausted both theories. And to the extent that the EEOC or whoever drafts those documents thinks it's relevant. They don't really think that it's relevant to direct the complainant to kind of distinguish between the two theories.
Your Honor, I would just say Ponce says that an individual has the obligation to raise it at least as summary judgment.
Right.
That's what this court.
That's a counsel.
Yeah.
So you would hold her to the counseled standard. If we were to agree with amicus that in ruling for summary judgment against a pro se plaintiff, the district court in an employment discrimination case should consider both a but-for and a motivating factor analysis, why shouldn't we remand to the district court to do the analysis that the district court didn't do?
Because, Your Honor, there's no evidence no disputed evidence that Ms. Tarquini has pointed to that shows the nexus anyway. There still needs to be a factual connection between the adverse action, which is here the termination, and her membership in a protected class. And she has not presented any evidence that would show that it was all protectual or that her membership in her membership in a protected class is the reason for the termination itself.
A reason. Yeah. So Mr. Harris talked about the range of statements going on over a long period of time that a reasonable jury might find events, attitude of sex and or race discrimination, even if you think the IG report was a but-for cause. How do you exclude that attitude toward this employee as a motivating factor? And I guess I would add in there the comparators. We have identification of people. I think the comparators in this case, maybe what's relevant is who is a sort of middle level manager, not are you under the exact same people, but people who have a responsibility. I mean, one of the things that was said when Ms. Tarquini was, defense of terminating her was, well, she was an HR person. She had to be exemplary. But then you have people in, similarly important positions negligently causing a loss to the Navy of $300,000 or causing $175,000 merchandise deficiency, or Mr. Holsopple, engaging in unlawful conduct or suppressing correction thereof. Why are those not also circumstantial evidence that this employee was treated worse?
So, Your Honor, this court in Joyner said that comparator evidence needs to be nearly identical, and none of the individuals that
for materially nearly identical. And what I'm saying is, doesn't have to be there's only one presumably position like the one that the plaintiff here held. And so you have to look at other kind of people with some responsibility over a function. So maybe it is nearly identical if somebody responsible for a function of inventory of merchandise causes a loss of $175,000 of merchandise. Maybe that is comparable to somebody in HR doing something in hiring that's considered highly irregular.
I would say it's not, Your Honor, because again, Ms. Tarquini is uniquely positioned to be in a place where she could influence hiring and firing decisions. That's the position that she's using, and it's not comparable to someone that has oversight over funds and things like that. Mr. Harris pointing to Mr. Holsopple, again, very different circumstances, different position where there, of course, assuming that those allegations and everything are true about Mr. Holsopple committing misconduct, they are incredibly different than what Mr.
So tell us give me some more granularity about what are the accusations against Mr. Holsopple? Why, in his position, not comparable in seriousness?
So my understanding about the allegations of Mr. Holsopple were
the evidence against.
Yeah, was that he had used his position. He had not investigated sexual harassment. I don't recall in the record allegations about sexual assault. I know my friend mentioned that, but I don't recall that in the record. I could be wrong. but that he didn't properly investigate things. He may have mismanaged some funds. But again, I would point to the fact that Mr. Tarquini was the chief of HR.
And his position?
If Your Honor will give me one moment, I'll just look at he was the chief of MNFP. I think it was like of something in funds appropriation. But Your Honor, I think we're talking about a night and day difference between Mr. Tarquini and Mr. Holzapfel here.
What about the statements?
From
Time of the month and all that kind of stuff.
I think
This seems like a kind of textbook case where the government has a really good reason for doing what it's doing, and plaintiff is not going to win on but for, but there's at least some evidence that the bad motive is in the air.
this court has said that stray remarks aren't enough, and I think we need to be careful about imposing what almost would be a hostile work environment theory into.
But it's not. There's an action here. The hostile work environment theory, the comments are creating the adverse action. Here, we're just talking about what is the orientation of these supervisors toward this employee. And to say stray remarks, I mean, it wasn't just one, sweetheart. This was she, at least as she would testify to, a litany of some really pretty, sex-based and derogatory comments.
I would say, Your Honor, I think the comments about this time of month obviously are sex-based. I'm not disputing.
And not to be taken lightly.
No,
very undermining.
Your Honor, assuming those allegations are true, we obviously would say that we don't stand by them. They are inappropriate in the workplace, no question about it. But the question is whether or not Ms. Tarquini can point to any evidence that would connect those comments to the termination. And she hasn't. And that's the point, is that even under a mixed motive theory, she still needs some factual hook.
Sorry, none of those comments is from the direct supervisor or the second line supervisor.
They were, I think there were some comments from Mr. Johnson, some comments from Mr. Iwanek. I don't think that's I would say for summary judgment, that's not enough. This court has said that it needs to be more than just a disputed fact. It has to be that a reasonable jury can infer discrimination. And just based on those comments, I don't think that a reasonable jury could infer given given the record.
So when you say that a reasonable jury could not infer discrimination, you mean infer discrimination with respect to the challenged employment action, the challenged adverse action. That's what you're saying the standard is?
Yes, to the termination.
So if someone hypothetically, if the supervisor, constantly refers to an African American with the N-word, including, days before terminating the person, but then terminates them based on, let's say, an inspector general report that they committed some wrongdoing, you would say that in that case, there's not enough to go to the jury, even on a mixed motive theory, that racial discrimination had anything to do with the termination?
I wouldn't say that, Your Honor, only because I know this court's decision and IEC, says that one use can be enough for a hostile work environment claim. I understand it's a different context and different claim, but I think there we have enough to have a causal connection.
I'm sorry, which case?
Because the N-word was used?
Well,
That's what makes it enough?
I believe the case is IEC AYISSI. Your Honor, that's what the panel said. And
well, that's talking about hostile work environment. So let's say the N-word is not used, but it's just, you people and a lot of derogatory things that a reasonable jury could say clearly show a hostility or animus towards someone because of their race. That there's various of those statements that are made, including up to about a week before the termination. And the termination is based on an inspector general report that found some other unrelated wrongdoing. So you're saying, so no N-word, but evidence that could be fairly construed as displaying racial animus. So you're saying in that case, there wouldn't be enough to go to the jury?
I think there could be, and I think that's this court's decision in Morris, where there were more racially explicit comments being made, and then the court reversed a grant of summary judgment and sent it back. But again, I think the issue, the key there was that this court saying there was a factual connection, or there was evidence in the record that connected the comments to the actual adverse action at issue. And that's
factual connection. I just read Morris yesterday, but you're thinking the factual connection you're thinking of?
so I believe there were different categories of evidence in Morris, and if Your Honor will give me, it was the multiple statements, and I'll just quote the court. It was the number and tenor of the racially charged comments that connected, that added the connection between the.
I'm not sure I see a difference there, though. I mean, there's a number and tenor of remarks here that are, you know, gender explicit. There they were race explicit. There were derogatory statements about white girls or white boys by a African-American manager, and that was held to be enough of a link in that context, right?
Yes, Your Honor, but again, it was a connection of, if I remember Morris also correctly, there was comments of replacing certain people and not giving Morris an opportunity to apply, or not putting her in that position.
Okay, so that was not what you said.
Yeah, sorry. So that is the distinction here. Is again what juries interpret facts. They look at facts. That's what the standard is. And Ms. Tarquini is missing that.
Thank you.
Thank you, Your Honor.
And if you want, you don't have to take rebuttal time, but if you want it, you're welcome to a minute.
A lot to respond to, but I will try to be as quick as I can. So the government said it again, that the termination was based on hire, which differs again from the termination letter from Colonel Boucher and Mr. Iwanek, which both state employment. And to your point, you said, is there a reason something around the government had justified reasons, but I have counted 6 different notifications of charges, or 6 different changing reasons, I should say. Johnston's proposal said facilitated the hire. That's at JA 1386. Iwanek said regarding the employment misconduct. That's at JA 1029. Then Iwanek said it was based on poor performance and refusal to take responsibility, which isn't in any of the documents, and that's in JA 303. Then Iwanek told Boucher that it was for poor performance, inability to take responsibility, poor leadership and management abilities. That's at JA 307. That's changing again. The 5th one was Jody Devine, the attorney, said that it was based on inappropriately involvement in employment. That's at JA 2170. And then the 6th time was Jody Devine saying the termination was based for involvement in a process that she admitted was within policy. And that was at JA 2175. That is 6 different times that the charges have changed.
I have a question about the theory that we probed with Mr. Harris and Mr. Sampat. You now know from the brief that amicus has filed in support of your case that there's these 2 different theories, but for causation and motivating factor. But for causation, you have to show if the discrimination that your evidence, if a jury were to believe your evidence, and you took away the discrimination, you wouldn't have been fired. That's the but for causation. It's like if there were no discrimination, you would still be working there. But there's another lower standard that you can show you were subjected to discrimination if it was a motivating factor. It was in the mix. Even if it wasn't, you could take it away and it might still have happened. And the theory there, I think, is Congress is saying, we just don't want people to have to deal with discrimination that actually is affecting people in the workplace. But if you win on the easier to show, you don't get as much in terms of relief if you win as you would. So my question for you is, and the district court only considered whether in the absence of discrimination, would you still have the job? And he said, no jury could find that you would still have the job, even if all the things you say were discrimination never happened. He's saying that the IG report alone is responsible, right? Are you wanting to press a case in which you might get a finding that discrimination was a factor, but you would not be entitled to back pay, any other damages, attorney's fees, but you might get some kind of declaration that discrimination was in the mix? Is that something that you believe you are pursuing and want to pursue? Not to the, at all.
So I just want to pursue a fair process. I feel as though I have never received a fair process from the beginning. He made comments as in, don't grieve this like a little girl. I want to date you, kid. I love you, kid. You were talking about sexual harassment. There is a lot more in the case that I can explain in just a few minutes, but there's a lot more in the case that I've reported to headquarters. It's all in the files. And in the files itself, the government deleted my files right before the hearing. They deleted all of my emails before the hearing itself. So there's just a whole lot there, but all of that was reported. It is contemporaneous in my notes. Headquarters also wrote their own notes to the facts as well. Everything is well documented as far as the sexual harassment, as far as the discrimination, as far as the retaliation, and even hostile work environment. And I will say, as far as Carrie Holsapple, Jason Gardner, Vincent Anderson, even when they were given the evidence for their file, they were able to review it in an open office or in their office. I was at a police station with armed guards, with Lieutenant Colonel Scott Manning right there with a partial file, so it was never access. So what the judge pointed to was my Facebook comment that said I had access. The access was a partial file that was never released over a 10-year period. So access is not the same as receiving the entire file itself. It's understanding the evidence that they claim they used to terminate me, if not for discrimination, if not because I had a disability and because I requested an accommodation and they denied that a few weeks before. That is the temporal proximity of what actually happened to the employment decision that happened after that. It was all connected.
Anything more? I know this is upsetting and you're doing an admirable job as a non-lawyer in a very high pressure kind of situation. So thank you for your argument. And we'll hear now from rebuttal from Mr. Harris.
Just a few things, Your Honors. Judge Pillar, before I forget, the portion of the Iwanic deposition that you were asking about is available at JA 768. And you were also asking whether Ms. Tarquini put the statements about that time of month in front of the district court. It is paragraph 10 of her opposition to the government's motion for summary judgment. On the waiver point, the government concedes that Tarquini put her eggs in the basket of pressing discrimination in her briefing before the district court and its summary judgment. That includes a but-for theory of causation and, given the pro se circumstances of this case and the particular filings and arguments that Tarquini pursued below, a motivating factor theory of discrimination. If you look at JA 907.
Do you think same brief, same summary judgment brief, but in a counseled case, would the brief have been enough on the facts of the case to preserve both theories?
I think the court doesn't need to get there, Judge Katsas, but
I know, but please answer.
yeah, I think it does. You know,
Good enough to preserve both?
good enough to preserve both. What the Ninth Circuit said in Stiegel on page 1071 of that case, although Stiegel does not expressly designate her case a mixed motives case, both her brief and the record reveal that it can be construed as one. I think that applies to this case in the briefing that Tarquini submitted to the district court. But again, I don't think the court needs to get there. I think it can find this because Tarquini was proceeding pro se below.
And that's not inconsistent with, I think it's Pons, where we said somebody may want to disclaim that, and because they really want to press the jury to find but for or nothing, that would be accomplished by a disclaimer on the part of the plaintiff.
That's right, Your Honor. I think this gets at what Judge Katsas had in his colloquy with the government earlier. A litigant could disclaim outright a mixed motives theory and say, I only want to proceed under a but-for theory of causation. That would be waiver, not forfeiture. Here, I think you have just the failure to specifically use the words motivating factor. But given that it's a lesser evidentiary standard, invoking discrimination repeatedly and arguing the causation standard is enough in a pro se filing. And the other thing I'd point the court to is JA 907. This is Tarquini's letter of appeal to Colonel Boucher. It's in the record at summary judgment, where she asserted, quote, Mr. Owanek's discrimination contributed to Ms. Tarquini's adverse employment actions in violation of Title VII. It is not as if, you know, at no point during these proceedings or during her time pressing this claim, she disclaimed mixed motive. In fact, it's just the opposite. On the nexus point, Your Honors, this court's precedents are clear that when the key decision makers exhibit discriminatory animus at or around the time of an adverse employment action in comments directed towards the Title VII plaintiff, that is enough to get past summary judgment. That's what this court said in Morris. It's what this court said in Mayorga. And I think this court's reasoning in De Jesus is particularly on point. There, the court said a reasonable jury could treat evidence of a decision maker's broad-based racial animus or bias as corroborating evidence that such animus infected a particular employment decision. In fact, it is not unreasonable to doubt that an employer quarantines her animus or bias to day-to-day treatment of colleagues away from decisions about hiring, promotion, or termination. That applies directly to the circumstances here, where the key decision makers are exhibiting a pattern of conduct and comments that exhibit discriminatory animus. Also on the nexus point, Your Honor, I think the key thing is that this is a classic case in which a fact finder should make the determination whether the discriminatory animus infected the adverse employment action. And for that reason, Your Honors, I also think if this court is going to send back the case on a mixed motive theory, it makes sense to vacate the but-for causation theory that the district court analyzed. The reasons it invoked, isolated comments a significant time before the adverse employment action, do not hold up to the record. And a fact finder could find that but-for race or sex, Tarquini would not have been fired, especially because the decision makers here talked about invoking other rationales behind the termination besides the investigative report. If there are no further questions, I ask that the district court's decision be reversed. Thank you.
Thank you. And I want to recognize, thank you, Mr. Harris. You were appointed by the court to act as amicus for the appellant in this case, and the court thanks you very much for your assistance.
You're welcome.
The case is submitted.
No.
Case number 25-1106, the estate of Stephen M. Jennions, petitioner versus Commodity Futures Trading Commission. Mr. Hasagawa for petitioner, Ms. Berry for respondent.
Your Honors, and may it please the court, Stephen Hasagawa for the estate of Stephen Jennions. The CFTC's denial of an award, I'm sorry, I'm going to reserve 2 minutes of my time for rebuttal. Your Honors, the CFTC's denial of an award is arbitrary, capricious, and contrary to law for two reasons. First, the CFTC's determination that Jennions was not an original source of the information that caused the CFTC to open its investigation is not supported by substantial evidence. In fact, it's contradicted by the only evidence in the record on that point. And second, the CFTC did not follow the procedures that are mandatory in the CFTC's own regulations for the resolution of whistleblower award claims. That irregular procedure led to an irregular and incorrect result. So I'd like to first address substantial evidence. The uncontroverted record establishes three facts that refute the stated basis for the CFTC's denial of an award. First, Mr. Jennions was an original source of information in the Bloomberg article. Second, the Bloomberg article as a whole, including information of which Mr. Jennions is the original source, caused the opening of the CFTC's investigation. And third, Mr. Jennions' information was sufficiently specific, credible, and timely to cause the opening of the investigation, as evidenced by the fact that it did. So as to those facts, I would like to address each of them in turn. As to the first fact, the record is uncontradicted that Jennions was an original source of the information in the Bloomberg article. That article reported on allegations of the manipulation of a benchmark foreign exchange rate, the WMR rate, and it quoted the UK Financial Conduct Authority's statement that it was, quote, aware of these allegations, close quote. The CFTC acknowledges that it understood the quote from the FCA to mean that the FCA was aware from an independent source of, quote, allegations of manipulation of the fix, end quote, meaning the...
So you're saying that the original source, a source that the Bloomberg article itself identifies is the UK FCA, and then in turn that Jennions had spoken to the UK FCA?
Yeah, yes, that's right. That Mr. Jennings was the original source of information that the FCA provided to the Bloomberg reporter and was quoted in the Bloomberg article.
And how do we know that?
So we know that because the record is uncontradicted. First of all, at 329 to 331 of the record, the FCA provides a letter where it says Mr. Jennions was in fact the original source of its information. In that same passage, 329 to 331, it says that in January of 2013, Mr. Jennions provided it information. In February of 2013, Mr. Jennions sat for a day-long interview with the UK Financial Conduct Authority, and that's also in the record at page 82. In fact, the record establishes that at the time of the Bloomberg article, Mr. Jennions was the only source of the FCA's knowledge. Since, as the FCA points out, the FCA had only done two things at that point. One was gather information from Mr. Jennions, and the other was collect some data on trades without yet identifying anything of concern in that data. And that's in the record at 228. 246, 264, 282, and 300. So we know that Mr. Jennions was the only source of the information that the FCA provided in the Bloomberg article. And the CFTC acknowledges that it understood the FCA's quote in the Bloomberg article to mean that the FCA was inquiring into the conduct, a defined term that meant the allegations of manipulation of benchmark currency rates, including the WMR rate. In other words, the same allegations that are reported elsewhere in the Bloomberg article. And that's at 347 to 48, 359 to 60, 371 to 72, 383 to 84, and 395 to 96 of the record. Now, the CFTC is taking the position that Mr. Jennions was not an original source of that information because Bloomberg did not get the information directly from Mr. Jennions. But the original source provision is asking who is the original source? What is the origin of this information?
But didn't Mr. Jennings write to the FCA in an email in January of 2013 and never mentioned that he was a source for the Bloomberg article?
So January 2013 was before the Bloomberg article. January 2013, Mr. Jennions first wrote to the FCA and said, I'd like you to understand that the banks are manipulating the WMR rate. And then in February of 2013, they sat down and interviewed him. In June of 2013, the Bloomberg reporter reached out to the FCA and said, we're aware of these allegations from other sources of this information. And the FCA said, yes, we also have a source that is telling us the same information, that there's manipulation of the WMR rate. And they were quoted in the article as saying that. So it is true that Mr. Jennions did not speak directly to the Bloomberg reporter, but that's not necessary for application of the original source test, because again, the words original source connote origin. What is the origin of the information? And it's true that the Bloomberg reporter received that information from first in the last instance from the FCA, but in fact the origin of the information was Mr. Jennions, and the record is absolutely clear.
But Mr. Jennings, there's no evidence in the record that he directly spoke to Bloomberg, right?
He did not speak directly to Bloomberg.
So Bloomberg calls the FCA, right?
That's correct.
So they've already got a story and they call the FCA. So by definition, they knew something about this before they contacted the FCA.
It is true that Bloomberg had other sources aside from the FCA. Our point is that the FCA was an additional source. The FCA provided information to the Bloomberg reporter that said, yes, we also have the same information from an independent source. That this rate is being manipulated. And as a matter of fact, the information is sufficiently serious for us to be investigating. We've opened an inquiry is what the FCA said. And that information, of course, through the Bloomberg article reached the CFTC, which
I'm not sure how that can be original source information in the sense that if Bloomberg already has, was it 5 different people in the business who it had talked to, it had information. It turns out that in parallel in the UK, there's something going on. Mr. Jennions was the source for the UK FCA, and Bloomberg confirms that. But how could it be the original source if Bloomberg already had information from these other 5?
Well, Your Honor, the Bloomberg article as a whole contains multiple sources.
Yep.
And each of those sources is an original source. I'm not suggesting that Mr. Jennions was the only source in the Bloomberg article. I'm saying that Mr. Jennions was the original source of some of the information in the Bloomberg article. So there were 5 traders, that's true. There was also a 6th source, the FCA, quoted in the article as saying, we are aware of these allegations, which, as again, the CFTC has conceded, means that the FCA had was itself aware from an independent source of the same information as the other traders. So there were 6 sources of that information, and all 6 of those sources are original sources under the original source rule. Again, what's the CFTC has tried to do in reading that is to say the word from that in the definition of original source, that the Bloomberg reporter needed to obtain that information from the source. It ignores the fact that the key to the original source test is trying to find the origin, and the term from is a term that encompasses that, particularly in the context of an original source examination. So I'd like to go on to the second fact. The record is clear and uncontroverted that it was the Bloomberg article as a whole that caused the CFTC to open its investigation and not any particular information in it. The CFTC acknowledged 21 times in the record that the Bloomberg article was the precipitating cause of its investigation, and it refers to it only as the Bloomberg article. It doesn't say 5 traders in the Bloomberg article. It doesn't say any particular portion of the Bloomberg article. That's it.
What's your best authority for if we were to find that he was one of the sources indirectly for the Bloomberg article through the FCA, and that the Bloomberg article caused the investigation? What's your best authority that makes him an original source?
Well, Your Honor, first I would say there are the textual clues, and second, the contextual clues. The textual clue is that the original source question is at its base, as the the words original source say, we're looking for the origin of the information, not the last, most recent source of information. And if the CFTC had intended to rely only on the most recent source of the information, it could have written a regulation that said that. Instead, it said, we want to find out who's the original source, not a secondary or derivative source. Who is the original source of this
Can
information?
you tell me a case where a court has interpreted the rule as you are asking us to?
Unfortunately, Your Honor, there are very few authorities interpreting the statute, and in particular, I believe there are none interpreting the original source language.
The statute requires causation as well as original source, right?
Well, causation of an enumerated action.
Led to the successful enforcement.
That's right. That's right. And
usually, when statutes require causation, courts read that to mean proximate cause, substantial cause, not just any old trivial cause. So what's your best argument? He's one of 6 sources, comes to the CFTC indirectly. That sounds like a pretty marginal cause to me.
It's not, Your Honor. First of all, I would disagree with the notion that it is a trivial cause. In fact, it was the information that started a sister agency on its process of engaging in an investigation that was performed in parallel with the CFTC's investigation that recovered an awful lot of money. But the second thing,
substantial for UK enforcement, no doubt, but the causal chain is different.
Well, I think it's both, because to the extent that there are 6 different sources in the Bloomberg article, there's nothing in the statute that requires that there only be a single source. And in fact, it's quite common in both the CFTC context and in the SEC Dodd-Frank whistleblower regulations for there to be multiple whistleblowers who receive awards. They make that decision all the time. And in fact, if there were 6 people who came in this instance and said, I was the original source of the Bloomberg article, and they complied with all of the other requirements of the statute, the CFTC would be well within its rights to say each of the 6 of you is entitled to an award because each of the six of you was an original source of the information that caused us to open the investigation.
The CFTC, though, concludes that the Bloomberg article didn't actually recount any of Jennings's information. It just recounted the fact of the UK FCA having talked to him, but there's not like details of the information. The article is really based on the information provided by the other 5.
Well, but Your Honor, the article, it only quotes the portion, the FCA, to the extent that it says that the FCA was aware of these allegations. But the CFTC acknowledges that that is a statement by the FCA that it has an independent source for the same information that is being reported elsewhere in the article. And that's in the record at 228.
But that's not even a statement by the FCA that it is conducting an investigation.
It also says that. The FCA also says that. It says we're inquiring of the relevant parties in the Bloomberg article.
It says we're speaking to the relevant parties. That doesn't mean that they're undertaking an investigation.
It was, Your Honor, in the formal processes of the FCA, my understanding is that the inquiries are precedent to an investigation, but they are all part of a chain of events that leads to what they refer to internally, formally as an investigation. But in the record at 329 to 331, the FCA says very clearly that Mr. Jennions was the source of the information that they were relying on in reaching out and beginning to inquire of those relevant parties. And then, of course, the FCA's inquiries became an investigation, and they ultimately led to the recovery of substantial funds in parallel with the CFTC's investigation.
My point is that if the Bloomberg article was the catalyst, and the Bloomberg article uses the FCA as one of the sources, and all the FCA says is that we are aware of allegations and we are speaking to relevant parties. That's not even corroborating like that the FCA believes that any of this is true or has any merit. It's just saying we're talking to people.
Now, Your Honor.
So it's not even relaying the substance of what Mr. Jennions told them, right? So with respect to the other people that Bloomberg spoke to, they gave them details of the manipulation that they believed was going on. But what they got from the FCA, at least what's reported in the article, is just that, yeah, we're aware of some allegations and we're speaking to people, but not even like corroborating anything or passing on substantively anything that Mr. Jennions told them.
I think that it's important to read the FCA's quote as having content. And the content of the quote is these allegations, meaning in the context of the article, it can only refer to the other information, the information elsewhere reported in the article. In other words, the FCA was aware of the same information that is being reported elsewhere. That's what the FCA was saying. And it's true that it was shorthand. Often reporters don't include the full quote. I know that from experience, but the fact is that the CFTC itself acknowledges that what the FCA was talking about was its awareness from an independent source of allegations of manipulation of the foreign exchange, the key foreign exchange benchmark rate, the WMR rate, and that's in the record multiple times: 348, 7 to 48, 359 to 60, 371 to 72, 383 to 84, 395 to 96. It's also separately in there at 228, 246, 264, 282, and 300. And we do also know, contrary to the post hoc arguments in the CFTC's brief and in the final order, that the information from the FCA was important to the CFTC. We know from the record that the first thing that the CFTC did upon opening its own investigation was reach out to the FCA. That's in the record at 228, 246, 264, 282, and 300. I'm sorry, that's wrong. That's in the record at 443, 447, 451, 455, and 459. And then shortly thereafter, it convened an investigative team. And the first thing that the investigative team did was reach out to the FCA again. That's in the record at 228, 246, 264, 282, and 300. So the record itself contradicts any argument that the FCA's information in the Bloomberg article was not important. The first thing that the CFTC did twice when it opened its investigation was reach out to the CFTC.
I guess my point, not to beat the dead horse, is that even granting all of that, just because that might be the first place they went to try to seek some help or to get some corroborating information, that does not prove that that is what caused them to open the investigation. If I see that, all of the cookies have been eaten in my kitchen, the first person I might ask as to why all the cookies are gone might be, my oldest child or something, but that doesn't mean that, I've been told anything. I just know that that's a good person to ask, right?
Well, I would say, Your Honor, that what the record does say is that the article was the cause of the opening of the investigation. And it says it quite clearly. And like I said, it says it 21 times. It's in the record, all over the record. And there's not a single thing in the record, not a single suggestion anywhere in the record other than the final order, which doesn't cite any of the evidentiary record. There's not a single thing that suggests that it is any particular portion of the article. It was the article itself, and that's the only evidence that we have in the record, that the entirety of the article is what caused the opening of the investigation. And in that instance, being an original source of one original source, not necessarily the only original source, but being an original source of the information in the article is sufficient to trigger the rule that Mr. Jennions is an original source of the information that led to the opening of the investigation.
I wonder if you could talk about the argument that the commission exercised undue control, that the office of General Counsel improperly participated in or controlled the commission's decision.
Thank you, Your Honor. It is true. We do not know exactly what procedures the CFTC used to reach its decision, but we know that they are not the procedures that are specified in the statute. And we know that, and it's in the record, very clearly in the record, because the regulation requires that the whistleblower office perform certain acts and that we perform certain acts with respect to the whistleblower office in order to get through the process. And the whistleblower office, in fact, was completely cut out of that process. 17 CFR 165.7G requires that the whistleblower office send us the preliminary determination. That's prior to the final order. We did not receive that from the whistleblower office. We received it from the Office of Chief Counsel of the Division of Enforcement, contrary to what the regulation requires. We wrote back, as the statute or as the regulation requires us, we wrote back to the whistleblower office, and we included the Office of Chief Counsel because it came from them. And we were told, don't write to us, don't write to the whistleblower office, write to us, the Office of Chief Counsel. That's at 344 to 45. We continued to correspond with the whistleblower office because, again, that's what the regulation requires us to do in 165.7G2. And we were told again, in the record at 434 from the OCC, stop writing to the whistleblower office, write to us, the Office of Chief Counsel. So we know for a fact that the whistleblower office was cut out of the process. Because of that, we asked the CFTC as part of when we were asking it to prepare a record, an administrative record, to tell us what role the Office of General Counsel for the CFTC had in the process and how the claims review staff or the CRS was constituted. That's in the record at 431 to 432.
I guess I'm sorry, Mr. Hasegawa. I'm not entirely following what the core of the argument is. It seems like I took your brief to be saying that somehow the commission's regulations limit the Office of General Counsel's ability to participate in the claims review process. They do have they're tasked with doing a legal sufficiency review, and the CRS can't be composed of OGC staff, but I'm not sure that I can infer from that they can't otherwise coordinate.
Well,
and what's just in sort of common sense terms, what is the nefarious or irregular or erroneous process that you're actually complaining about?
Your Honor, in common sense terms, the regulation provides one role and one role only for the Office of General Counsel, and that's legal sufficiency review. And it does that for a very important reason. And in the process of doing that, by the way, it excludes the Office of General Counsel from the claims review staff or the CRS that makes the initial determinations and recommendations of awards. It does it for a very important reason, which is that the CFTC was very concerned to make sure that the legal sufficiency review was being performed by an office that did not have a stake in the merits determination. Because we know that if you want an unbiased review of the legal sufficiency of an action, you should not make the person who had input into that action itself the person who's reviewing its legal sufficiency. Otherwise, you get bias in favor of confirmation. And in this instance, we don't know exactly what role OGC played, although certainly CFTC is not denying that it played an important role. I think that it is worth noting for context that this is one of the two largest recoveries that the CFTC has ever made, the two largest whistleblower applications that there have been. And in both of those instances, OGC has usurped the role of the whistleblower office in making those determinations. And certainly since they have departed from the procedures, we have rebutted the presumption of regularity and can suggest that there maybe was something else going on when they were deciding.
You still have to, under the APA, there's still a rule of prejudicial error. You still have to show that this isn't that, okay, there might have been error, but that it's not harmless. And I don't see anywhere in your brief where you address that aspect of 706.
Your Honor, I do think that it was not harmless error. And the reason I think that is because the legal sufficiency review, which is all of the stuff that we've been arguing about, both in this hearing and in the underlying briefs below, the only review we got was by a party who seemed to be very interested in confirming the underlying decision to deny an award. And we saw that it manifest itself in a series of shifting explanations for what was underlying the CFTC's decision. First, it was the self-reporting, and then it was the Bloomberg article as a whole. And then in the final order, unsupported by any evidence, it was only really a portion of the information in the Bloomberg article. We also saw the assertion of the 180-day rule, which we demonstrated was not applicable since it was not enacted in the regulation until long after we had submitted our materials to both the FCA and the CFTC. They forewent that in the final order, but seem to have resurrected it, at least in shadow form in the briefs before this court. What we see is an agency that is looking for reasons to support the decision, the merits-based decision that was made, and we think that the participation of the OGC in those merits-based decisions was what's causing this bias in favor of confirmation rather than the neutral legal sufficiency review to which we're entitled.
All right. We'll hear from you on rebuttal. You've reserved some time, and we need to hear from Ms. Berry. Am I pronouncing it right?
Yes. Good afternoon. May it please the court, Ragini Berry for the respondent, Commodity Futures Trading Commission. The bottom line here is the CFTC did not obtain petitioner's information from any source before the commission settled the cases for which he now seeks a whistleblower award. This fact alone is determinative of the appeal, because if he did not timely provide qualifying information, he cannot have provided information that led to the successful enforcement actions as is required for an award. This afternoon, I would like to address petitioner's derivative source theories as various theories, none of which entitle him to an award. Now, there are two rules that are applicable here. The first is 165.2I, under which petitioner must have provided information that was sufficiently specific, credible, and timely to cause the CFTC to investigate. And that also reports the conduct that formed the basis of the successful enforcement action. The second rule is the derivative source rule, under which if the commission obtained petitioner's qualifying information that I just described from another source, then he may qualify for an award. Petitioner relies exclusively on the FCA's quote to argue that it was sufficient for him to report the conduct. But the FCA's quote in the Bloomberg article does not satisfy the requirements of 165.2 because all it does was give the FCA's information that it was aware of the allegations and that the FCA was speaking to relevant parties. None of it provides information that satisfies Rule 165.2's specificity requirements about conduct, about the underlying conduct that the CFTC charged. Now, I think petitioner recognizes this.
Couldn't in fairness, it would be, you could read that as saying that they are aware of allegations of the same nature as the other allegations that Bloomberg is reporting? Because otherwise, why is it even relevant for them to say anything?
That still wouldn't make this petitioner's information. The FCA's awareness of the other allegations is the FCA's information. It may be admitting that they possess similar information, excuse me, but that quote still does not report the conduct with any specificity.
So I guess there's 2 points that I hear the petitioner making. One is that by saying we're aware of these allegations, they mean specific allegations, and they're aware of them because somebody has told them of specific allegations. So A, they wouldn't say that unless they're talking about allegations of the same ilk as the ones that Bloomberg is reporting. And then I hear your friend on the other side saying, B, it's uncontested that at that point in time, the information that the FCA had received was from Mr. Jennions. So together, those two things show that he was an original source. That's the argument.
I don't think, excuse me, I don't think that those together show that he was an original source of the other allegations that the Bloomberg article details. Those were sourced to 5 other traders with firsthand information. I don't think anything in the FCA's quote actually corroborates what the Bloomberg article reports. It simply says, we are aware. It doesn't provide evidence of the misconduct.
We are aware of these allegations, not even evidence.
Right. There's no evidence that the FCA did not provide any corroborating evidence. And I believe they also argue that the two are inextricable. But I think the substantive allegations are easily understood without reference to the FCA's quote. The other argument that they make is that the commission essentially should be stopped from determining that the FCA quote was insufficient because declarations state that it was the Bloomberg article that prompted the investigation, and it doesn't specify. But the question here for petitioners' qualifications for an award is not what ultimately prompted the CFTC to investigate. The question is, did his information lead to the successful enforcement actions? And again, for that, you have to provide specific, credible, and timely information. The fact that the Bloomberg article prompted the investigations show at most that maybe some information in the article would satisfy Rule 165.2, not that all of it did. And if we went with petitioner's theory, you have several sources for the article, including a Forex trading advisor who said the Forex market is the Wild West, a fellow at the London School of Economics who stated that price rigging is extremely costly to society, a University of Florida professor who said it would be difficult.
That's really, I mean, let's be serious here. I mean, we wouldn't look at everything that was quoted in the article. We would look at who was quoted or who provided information on the article with respect to the wrongdoing. Those people aren't speaking about the wrongdoing. I don't think that petitioner is arguing that anybody who's quoted in the Bloomberg article is an original source.
Well, he's not arguing that they're original sources, but he's saying that we cannot walk away from the entirety of the Bloomberg article. And that brings us back to the point that the question is, was the petitioner's information specific, credible, and timely to cause the CFTC to investigate? That we don't focus on the entirety of the article, we focus on what was petitioner's information. And the only information he points to in the article as potentially his information is this FCA quote, which again, we do not believe is petitioner's information. It's the FCA's information. And even if it was his information, that quote by itself does not provide the information that's required under 165.2I.
So I just want to make sure that we're clear and I drill down on this issue. If Bloomberg speaks to 5 different people and they say that, you know, these specific types of actions are being undertaken and they are manipulating this market, and then Bloomberg calls the FCA and says, we're running a story about these sorts of allegations, that people are undertaking these sorts of actions to manipulate the market. And the FCA says, yeah, we're already aware of allegations that those actions have happened. Isn't that essentially confirmation that they have been told the same thing by one or more other people?
It confirms that someone has alleged to the FCA that this is happening. It does not confirm that the FCA has witnessed the conduct that is reported firsthand from firsthand sources in the Bloomberg article.
Understood that the FCA hasn't confirmed it. So what does the confirmation by the FCA have to do with applying the original source rule?
So the question, the question is whether the FCA is providing information about the conduct. So providing information about receiving allegations is not the same as providing specific conduct that formed the basis of the CFTC's action.
Why not? I mean, if somebody says, it's just sort of like, okay, here's this thing, I'm an American investigator, American government agency investigator, and I call my counterpart and say, we're seeing, this kind of conduct that we think is unlawful, ABCDE. And the counterpart says, yeah, we're seeing that too. And we're talking to people. And, oh, who are you talking to? Oh, that's not someone we've talked to. That doesn't count as original source information just because it's a confirmation of someone else's description?
That's different from what we have here.
Is it?
Yes, here we're saying, the FCA is saying, we have been told of these allegations. Not, we are also seeing this conduct. Let's talk.
By someone who is an industry insider like Jennions, how is that different?
Well, we hear from the Bloomberg article, we don't know that that's what's happening. All we do.
Your friend on the other side has said, we do know that Bloomberg, that the FCA says that or Bloomberg, I guess, says that this is our only source for the FCA. The FCA, that Jennions is the only source for the FCA.
Right. So I'm not disputing, and we're not disputing that Jennions may have been a source for the FCA.
Are you disputing that he was the only source for the FCA? As of the time of the Bloomberg article?
I believe he probably was the only source for the FCA, but I don't know that. And I don't know that that answer is in the record. But the issue is when the CFTC received information from Bloomberg, did it receive Jennions information? It did not. Nothing that Jennions reported to the FCA in the January 2013 email is attributed to the FCA in the Bloomberg article. So any sort of allegations that could match the specific allegations that Bloomberg obtained from these 5 other traders has not been reported through Bloomberg from the FCA. So that's the difference. If the FCA had said we have a whistleblower who has provided us with the same information, or we have a source that provided us with reports that match this, that gets you a little bit closer, a lot closer.
You're saying we're speaking to relevant parties. So it depends on whether you say source versus relevant parties.
Well, we don't know who relevant parties are. Is that in?
No, but it doesn't exclude sources.
It doesn't exclude, but that's not the test either. You have to have credible, specific, timely information about the conduct. It's not enough just to have your information in an article that caused the CFTC to investigate.
All right.
We respectfully ask the court to affirm the commission's decision.
Thank you. And you have 2 minutes late in the day, Mr. Hasegawa.
Thank you, Your Honor. I know that we're all getting hungry. I just want to address a couple of things. First of all, the CFTC's view of the specific, credible, and timely information requirement. In the briefs, the CFTC tries to separate that into 2 requirements. One, was the information under some unspecified standard sufficient? Was it specific, credible, and timely? And separately, did it cause the opening of the investigation or another of the enumerated actions? In fact, that's a misreading of the regulation. The regulation has a single requirement, and that is, was it sufficiently specific, credible, and timely to cause the opening of an investigation. And if it did that, then that is satisfaction. If you separate it into two, you read the words sufficient to cause out of the regulation, and that eliminates both the defined regulatory threshold that you need to meet and the causal test that you can use to satisfy it. In this case, the record, again, we are stuck with the record, and the record says that the article as a whole contained information that caused the CFTC to open its investigation. I think that it is not disputed that, in fact, the record establishes clearly that the only information that the FCA had at the time of the Bloomberg article was the information that comes from Mr. Jennions. Again, that's at 329 to 331 and 82 of the record. The CFTC has said repeatedly that the FCA had not done anything else other than obtain data on trades without identifying anything of concern in that data. That's 228, 246, 264, 282, and 300. So the FCA's quote can only be attributed to an original source of Mr. Jennions. There are no other sources in the record, at least, that suggest that there was anybody else behind that information. With that, I would say we request that the panels, that the court vacate the order denying an award, order the CFTC to make an award and remand to the CFTC for consideration of the appropriate amount within the 10 to 30% statutory range within which to make that award. Thank you, Your Honor.
Thank you. The case is submitted.
This honorable court now stands adjourned until Tuesday, April 7th at 9:30 a.m.
So much.
First, have a good one.
I was the only person who talked to them. I'm the lecturer.